forget to mention item number 20. My wife is in critical condition admitted in Orula Medical College Medical Hospital. What? Item number 20. In critical.
Both sides are referred. Who's for the other side?
Other side already G. Polita and G. Already informed.
Okay.
I pray for 3 weeks time.
Here made by Mr. and Dr. and the petitioner just after 3 weeks.
Civil division petition lordship, returnable debt is over lordship. Interim order is here lordship. They have more lordship.
Give it to the court master. They will make adjustments and.
May it please your lordship. Lordship, I beg for listing of 2 items, lordship. One is RSN, another is RFA, lordship.
May I please, your lordship, I beg to mention item number 10, your lordship. Your lordship, this matter actually compromise talk is going on between the parties. Lordship, it will be fixed in the last week of this month, your lordship. I did mention fixed to the very old matter. After 3 weeks, your lordship, 29th, lordship, it is Friday.
Both sides are represented. It is submitted at the bar that compromise is going on. Accordingly, John today, this on 29/5/2020.
Deeply.
Daily list item 1 for motion.
May please, your lordship. Now, in this case, what happened, my lord, for particular tutelar, the petitioner at first has filed TS number 13/24.
The if you order, which page?
Yes, madam. Interim order is the last page. Page 154 to 156. My lord, if your lordship, my lord, considering the manner that appeal will lie against this order, then I have no case. But if it can be restored, then I have a case. By
Not in, not by way of a, what you call, CRPIO, your execution case has been dismissed.
no. My that 238, this case 232 has been dismissed, which has been filed under that under order 21 rule 97/101.
Where is that petition?
Yes, that petition, madam, by additional affidavit, I have incorporated, madam. That is a counter record petition. By additional affidavit. So this petition has been dismissed. Where, madam, there is a stay order also, my lord. Stay of execution proceeding. This is the
Where is your petition?
in the additional affidavit I have filed.
Which page? Tell us the page.
Page 159. Sorry, yes, 157.
157 is your affidavit. Where is that petition?
Annexure 13 below.
Petitioner is annexed.
Annexure 13.
159 is the petition.
In additional affidavit filed by them.
In 159 is the petition.
Order. That is the decree to put into position.
No, my lord, they subsequently filed an additional affidavit. In that application, they have annexed the petition.
We are reading that. This shows the petition. That's a simple question I am asking.
But my petition,
That is a writ of possession. It's not a petition.
Page 159.
We are here.
Malad,
I am sending you here. I am sending you this.
Sir, paging maybe
I
Malad.
don't know, I am sending you this. I am sending you my what you call flag. Please flag it.
All of this also. Oh, it is not there in the file, my lord. It's not incorporated in the file. No, my lord, copy has that additional affidavit has not been, my lord, put in the file.
You show me a copy. Give me a copy.
That's okay. Oh. At the time this year. Year 19.
The present decree is in TS 63 of 2024.
Yes, madam. In the execution was, madam, proceeded on the decree of TS number 63 of 2024.
What happened to title suit 13 of 2024?
Yes, that is dismissed because the court has held that they are the same, my lord. So the earlier suit, the later suit will be, my lord, governed by the earlier suit. That way, that 13 of 64, 24 has been dismissed. So petitioner has no option other than to file this because he was not party in the suit 63 of 24. The same schedule, same land, which was, my lord, the earlier filed in 63, 13 of 24. the,
No, but in revision, you can't do it, and we don't find merit in your petition. You claim, you claim your rights from the, emanating from an agreement of 1956. So from 56 agreement, you are now trying to enforce in the year 2024.
I am in possession, my lord. The suit land I am in, that's why they have filed title execution. No, my lord, whether, my lord, this petition under this 227 lies, my lord, if it lies, then, my lord,
It won't lie. It's an appeal order. It's a decree.
then, my lord, I would not given liberty to file appeal.
My lord, in the meantime, decree has already been executed, my lord.
It's no problem.
So still, he has a right
Yes, my lord.
saving position on the basis of
Yes, yes. Even,
under 98. Okay.
Against that order, appeal lies, my lord.
okay, I am given liberty. I withdraw my lord.
Mr. P. Srinath, and then counsel for the petitioner. If to withdraw this petition, if liberty to file an appeal against the order issued in this revision under Article 227 of the Constitution of India. Mrs. Roy, Learned Counsel, here's for the respondent caveat. Hearing allowed, the active extent. This is on because liberty has been.
All right.
Caveat. This for the respondent field.
Obliged.
Item 2,
Okay, just a moment, and Sir Sinha, just put that lastly, say that the learned counsel for the respondent caveat submits that as per her instructions, from the decree has been executed. Court makes no observation on the said submissions.
Now, I have filed an additional affidavit. my
So
lord.
whatever, we don't say anything for that submission. You have said that, we have recorded it.
Obliged.
Yes.
item 2,
Well, the suit was filed, my lord, for realization of some money. This was based on a deed of agreement at Annexure 3, base 28,
Page 28.
base 28, my lord. And there is a money receipt also at page 31, Annexure 4, my lord. Now, the defendants, my lord, who are respondents herein, they took a stand that this deed of agreement, my lord, was not signed by them. So there was essentially a dispute as to the signature. My lord, the way the suit proceeded, however, is that PWs were examined, and at the stage after completion of DW cross, my lord, application was filed by the plaintiffs seeking for, my lord, referral of this matter for expert evidence as far as, my lord, the signature which is disputed is concerned.
This petition was filed at which stage?
My lord, the petition
At the
is,
time
my
of
lord,
argument.
originally, my lord, not enclosed in the CRP. There's an additional affidavit, my lord, at page 49.
No, it is stage of argument.
It is in the stage of argument now. Because after completion of, my lord, DW cross, it obviously goes for argument, my lord. So after completion, admittedly, my lord, this ought to have been or could have been filed earlier, my lord. At the stage of PW. But then my lord, contention is that, my lord, these are, as far as my lord procedure is concerned, it has to be considered as a handsmaid of justice, my lord,
Court in its wisdom has passed the order.
my lord.
We are not sitting in appeal.
I
We are
understand, my
sitting in
lord.
revision. So if you have any grievance against this order of sending the document for forensic examination, you can always raise it under order 41 rule 5. Sorry, 105. Let me apply here.
Well, the learned court actually went to a different aspect altogether. While passing the order rejecting my application, the court went into the dimension that expert evidence has little evidentiary value. And these are the judgments that are quoted in para 9. And based on that, my application has been rejected. These are, of course, my lord, matters of procedure, and my only submission that can be made as at this stage is, my lord, that these are procedure is supposed to be the handsmaid of justice.
Where is the order?
My lord, starts from page Annexure 1, page 16, it starts, my lord. The discussion of the learned court is from page 20, para 9.
Because you see, after the evidence and all, everything, it comes then, at the end, you say that you want a writing expert.
My lord. My lord, normally I also understand. At the stage of PW only, this application ought to have been made, my lord. But then our contention was that BW was, my lord,
You have a cross-examination, copy of cross-examination?
Yes,
of
my lord.
BW?
Yes, my lord.
Where is that?
BW, my lord, is at page 42, my lord.
42.
Page 42. And at page 44, my lord, this particular suggestion was made, my lord, on the signature, my lord. So the exhibit 1415193331 উল্লেখ কৰা সহি মোৰ সহি নহয় যদি উক্ত সহি ফৰেনচিকত যায় তাতে মোৰ কোনো আপত্তি নাই
If you feel aggrieved under 105, you can take it up in the first appeal.
my lord.
Mr. Sharma, 105 will apply to him. You get the benefit. 105.
Oh.
CPC. When he files an appeal, these interrogatory orders can be run.
Yes, it can still be considered, my lord. My case is that, my lord, without that evidence, in fact, I stand to technically lose the case, my lord. Because if the signature is disputed and I could not lead any evidence to the contrary, the suit essentially is lost, my lord.
Can't say anything, because you see that would lead to another way of looking at it.
My lord.
Can, after failure of the witness, will be permitted to allow further evidence to cure that defect?
My lord.
So that would also be no.
My lord.
Even if so come very quickly. The case of that Ibrahim Uddin, even order 41 to 27 would be made available to you.
My lord. In fact, the denial was there in the WS also, not just in the cross, my lord.
Yeah, Sharma, but also to be responsible. Filing this application under Article 227 of the Constitution of India. That read with section 115 of the CPC, petitioner, who is the defendant in the, plaintiff in the MS 66 of 2014, you are the plaintiff.
I'm the plaintiff.
66 of 2014 has essayed the order dated 5/1/2026, passed by the learned civil judge, in bracket senior division, bracket clause number 1, computed to Gauhati, in the said suit. By the imperial order, the application filed by the petitioner dash defendant for sending the signature of the respondent defendant for forensic examination of his, it's a thumb impression.
There is a thumb impression also in the money receipt.
So you are wanting to send what, thumb impression or signature?
They want to say, by the petition, they want to send in signature.
Signature in the alleged agreement dated 30/4/2011 for forensic. For this forensic was rejected. Next one, the learned counsel for the petitioner by referring to the cross-examination of the respondent as DW1. Has denied his signature and has expressed his no objection for presenting the exhibit 1 and his signature thereon for forensic examination. However, it is something said fact it's not appreciated in the correct perspective, and the application was dismissed. Merely on the ground that as the non-suit is pending since 2014, there is the whole case. And right at the conclusion that sending of the signatures of the defendant to the handwriting expert will not hamper the chances of the plaintiff to succeed in the suit. It's a non-sending of the signature for the defendant to the handwriting expert not to the plaintiff's successful. Next part. Having considered considering the issue involved in this application, what is of the considered opinion that this court, while exercising sovereign jurisdiction under Article 227 of the Constitution of India, not substitute its view over the considered decision of the learned trial court, and therefore court is of the view that the said opinion of expressed by the learned trial court in its order dated 5/1/2026 cannot be substituted by the view of this court. Next one. In the considered opinion of the court, the petitioner would not be prejudiced because of the fact that under section 105 of the CPC, it will be open to the petitioner to assail the imperial order dated 5/1/2026. I also advise the appellate stage and there are other provisions, appropriate provisions in the civil procedure code to take care of the plea of the petitioner for examining for the evidence in form of forensic examination of the of exhibit 1. Therefore, court does not find any reason to interfere with the impugned order dated 5/1/2026, asked by the learned civil judge in the senior division, was number 1, Kampur Metro from Gauhati, by which petition number 4427 of 2025 in MS number 66 of 2014 was dismissed. So, however, this the said order dated 5/1/2026 would not preclude the petitioner from exercising his right, which may flow from the provision of section 105 of the Civil Procedure Code.
Item 3.
The petitioner here also was awarded by the railway tribunal of 8 lakhs rupees lordship. And subsequently, but out of 8 lakhs lordship, she was paid only 1 lakh, and the remaining 7 lakhs was kept in FDRs for 14 years lordship of 50,000 each. So she filed a petition to release 50%, at least 50% of the awards, because she want to run a business, open a business for her son lordship.
Actually, my daughter is sought for instruction, but that instruction didn't come. And
There's no
what my learned
instruction.
friend,
You see, the money is lying in the tribunal.
yes, my
He
lord.
wants for some use. If the money lies for 14 years,
Let the matter be disposed of, my lord.
it wasn't-
Let the matter be disposed of.
we are sending it back to the, we are interfering with this order and sending it back for reconsideration of your prayer. Where is the statement you have made for your requirement of money?
Requirement of money lordship, even in the European order also, this reflect case we have made before the, here also we have made lordship.
They need the money for some business purpose, my lord.
Because she has 2 sons, lordship. One died and that award we got, and the other son, he is unemployed lordship. At paragraph 4 also he has stated lordship. Seven lordship.
You know, there's a reason to put this money in such deferred FDRs.
Yes, lordship.
Apart from the judgment
In Gita Devi,
passed in about 2006 or 7 by the Delhi High Court
Gita Devi's case.
and accepted by the Supreme Court of India to be a correct way. You see, the amount of compensation is 8 lakh. I hope you have advised the petitioner well. 8 lakh rupees, please tell me what sort of business the son can do. Son is an unemployed person.
Hmm.
What business with 8 lakh rupees they will be able to do in
They
today's?
gave, as I asked her, lordship, she wanted to open a grocery shop lordship in the village.
8 lakh rupees.
Not 8 lakhs, lordship, she wants 50% of the, 50%.
We understand, even if we pay you the entire amount, in 8 lakh rupees, will we be able to start a grocery shop?
Only in the village lordship. There will be some earning lordship for, because the mother and the son will can survive.
choice of the petitioner, but don't think it will be with all the money will be lost. It's the reason to protect the money.
Even there is a provision also, even after passing of the award, tribunal can examine
We are
the
not saying
claimant
that you are
against.
entitled to. We are saying that it is a considered decision. That's all we are asking. You're not giving any advisory role, what to do with the money, what not to do. Just asking whether it's a decision well taken. Okay, but Mr. R. K. Mohammed, then the petitioner, also that we need to take up on it. CGC appearing for the respondents. Next one. There is that petition.
The order look,
Petition.
it is in page 23, my lord. That miscellaneous application.
Yeah.
There has been filed before the honorable tribunal.
Right.
I find this application under Article 227 of the Constitution of India, the petitioner has said the order dated 7/3/2024. Where is that order?
Order is what, my lord?
Order located on page 28, 28. 17 to 26.
Seventeen to 2026. You have to amend your petition. The refusal of the tribunal to pass order is not that, it is 7/3/2025 order.
7/3/2025.
7/3/25, this petition is dismissed. Then you file another application for correction of the typographical error.
Yes, Lordship. And there, Lordship,
Even if you allow the typographical error, what will happen? Your money is still rejected. Tell me how you would get a relief in this prayer. You're not challenging the order dated 7/3/2025. You can't even touch that order.
7/23/2025 order was subsequently modified by correcting that. So we have come with the order. Because that order, that petition was kept pending for a long time, Lordship, because the tribunal it was lying pending.
We are very sure we pass the order.
Yes,
We'll make it clear that 7/3 order will not be touched by the tribunal.
7/3/2025 order was 2025 order was passed, Lordship. I have annexed that order.
Time to look into your prayer. We are telling you that it is defective and you still have submission. 7/3/2025 is the petition where your prayer was rejected.
Yes, yes.
That stands, and we modify the order where the order of corrections were not allowed, were not touched. How does it help you? You need the court as assistant to read your prayer, make you understand your mistake.
No, and give me a liberty to file a press petition.
You amend this.
Okay, amend it.
Can you amend it? It appears that in this application, the prayer that by an order dated 7/3/2025, the prayer made by the by the petitioner for release of the money kept in FDR was dismissed. Thereafter, the petitioner filed an application for correction of typographical error, which has crept in the order dated 7/3/2024, and the learned tribunal, railway claims tribunal gives any reference from the presentation in this projection in this application that in respect of the petition filed for correction of typographical error, the learned tribunal found no justification in premature release of the amount kept in the FDRs. Thus, there being no challenge to the order dated 7/3/2025, the learned counsel for the petitioner seeks liberty to file an application for amendment of this. Here made in this. application. Very good. Item 4,
Deeply obliged.
Item 4.
Yes.
where is the petition and where is the order?
At page 104, annexure 7,
Page number?
104.
And where is the petition?
Lordship,
Where is the petition under section 10?
it is it's page 86. That is the second application under section 10. Second application under section 10, Lordship.
Where is the first one? And where is the order?
Yes, Lordship. Annexure 2, page 61.
Page
61.
and where is the order?
Page 79, annexure 4.
And where is the first, where is the decree passed in the first suit?
They have instituted a suit in 2024, Lordship.
Where is that?
Subsequently, for
Where is that
that,
decree?
for declaration of tenancy, subsisting tenancy
Where is
right.
that? Where is that? Where is the earlier decree on the basis of which you have filed section 10?
There is no case is pending, Lordship.
Okay.
Subsequent suit was filed for ejectment of the tenant.
Where is the earlier suit then?
Then subsequent, that application was filed, Lordship. That is that case was for the declaration of subsisting tenancy right. And,
Where is the plaint?
plaint.
Have you two plaint?
Yes, Lordship. That is the,
Each?
Lordship, I will give you, Lordship. It is annexed with the plaint, of this 46, document number 6.
46.
46. We have annexed with this application before the court.
It's okay. And the other suit, where is that?
Page 57, Lordship.
This is the suit starts at page 46. Now, where is the earlier suit? Or another, the other suit?
This is the title suit filed by the defendant, Lordship.
And where is the suit on the basis of which section 10 is filed?
And now that title suit is 301, page 18. This is our suit. And in this case, issue has not been framed.
Just come on. Just come. And this contact the petitioner. Petitioners. Next. The agreed by the Impune order dated 5/2/2026, passed in Midge case number 383 of 2025, arising out of TS number 301 of 2024, passed by the learned civil judge, within bracket junior division, bracket close number 4, Kamrup Metro, Guwahati, by which the proceedings of TS number 301 of 2024 was stayed. The petitioner, who is the plaintiff, your substitution was allowed.
Lordship,
Was your substitution allowed?
yes, Lordship.
Which order?
I have not annexed, Lordship, but I have made statement here.
Where is that?
Yes, Lordship.
The substituted plaintiffs in packet code number 3.
Paragraph 2, page 4.
And plaintiffs were the substituted plaintiffs in packet code 301 2024. So the plaintiffs in this packet code 301 of 2024. Next part. It is projected that the respondent at this point of time had filed packet code 160 of 2024 for declarations that the respondent has a subsisting tenancy right in respect of the tenanted premises described in the schedule of the plate. And subsequently, the plaintiff, the petitioner, the predecessor of the petitioner, so attorney had filed a suit for eviction of the respondent. So however, as the plaintiff was filed in the name of a dead person, subsequently the substitution was allowed. It is further projected that on the here made by the respondent for stay of the proceedings of title sheet number 160 of 2024, comma, something wrong here. Something wrong here. The page 61 is by the respondent.
Yes, Lordship.
Page 61 is by the
Yes,
respondent.
their application
Let me-
under
let me-
section
let me
10.
complete. Page 61 is by the respondent. For prayer at page 66 is for the stay of the proceedings of 301,
Yes, Lordship. Subsequent suit.
subsequent suit.
Yes, Lordship. They have stated that they have already filed.
TS 301 of 2024. So the learned trial court by an order dated 13/8/2025 rejected the prayer for stay of suit stay of CS number 301 of 2024 under section 10 of the CPC.
That was Miss Petition
Subsequently-
19 of 25.
Subsequently, the respondent filed another application under section 10. This time in PS number 301 of 2024 for stay of the proceedings of title suit number 13, 301 of 2024.
Miss Case 383, Lordship.
However, this time the learned trial court by order dated 5/2/2026 passed in HJ case number 383 of 2025, arising out of TS 301 of 2024, take the proceedings of TS number 301 of 2024. Next. Accordingly, the state order dated 5/2/2026 is challenged in this application. Next part. If you notice to the respondent, it shows as to why the order dated 5/2/2026 should not be interfered with. Next part, the petitioner shall take steps for service of notice on the respondent by speed post PDD. Within 2 days. Next part. Next part, please. Petitioner is permitted to produce a certified copy of the order before the learned trial court to bring this order to the notice of the said learned court. Next part, list. Give a date after 4 weeks. So you should notice. Here's item 5.
May I please, Lordship? I'm appearing for respondent number 1.
Here in this case, Your Honor, the respondent has filed a suit for specific performance of contract, Your Honor, on the basis of a unregistered sale agreement, Your Honor. And accordingly, the petitioner has item 5.
Sorry, Lordship, I'm not on this case. I'm not on this case, Lordship. Sorry.
Accordingly, the present petitioner has been contested the case by filing their written statement. Your Honor, and that thereafter the matter has been kicked for the PWs, and accordingly the plaintiff witness and their cross-examination has been completed on 12/3/2025, and on that the matter has been kicked for the defendant evidence, Your Honor, on 9/7/2025. But the learned counsel, the learned court below,
take this matter at 2 o'clock. That's it.
That's good. Okay, tomorrow,
2 o'clock. At 4 o'clock. Just come.
yes, sir.
Plus.
May payment. Against the death of my mother, the petitioner filed one application under section 166. There the insurance company appeared and filed WA. Thereafter, I took 5 adjournments for filing evidence on affidavit. And on the 6th day, page 22, I also filed another application for adjournment. On the ground that I could not appear before on that day due to some unavoidable circumstances. That is page 22. And that petition was rejected by the learned tribunal below by order dated 21/2/26 at page 24. My lord. One, 1/2/2020. 2020. Yes. Pardon me.
You see, from page 24,
Yes.
it appears that from 19/9/2024
Yes.
till 21/2/2026,
Yes.
you were given adjournments, but you did not deduce any evidence.
Yes. Yes. That is fact.
For
I have
that
taken
is-
5 adjournments in
but-
paragraph.
But for that, there is no explanation.
My lord, the fact of the matter, I could not collect the charge sheet of the case for which the evidence was not filed. It was eventually I have received, but on that day, 21/2, I personally could not appear before the learned court below, for which, my lord, the evidence could not be filed. That is the fact, my lord.
Third, Mr. A. Bhattacharjee, then counsel to the petitioner. Agreed by the order dated 21/2/2026, asked by the learned member from a motor accident claims tribunal number 3, Roman 3. It is Roman 3 or numerical 3?
Page 24, it is 23, it is 3.
No, it is 3 only. It cannot be numerical. Numerical it should be. Numerical. Motor accident claims tribunal, that's 3, numerical 3. Come from Metro Gauhati. By which
Page 24 at top, it is written as Roman 3.
petition number, petition for adjournment was rejected and the case was fixed for DW.
Yes.
Is held by filing this application under Article 227 of the Constitution of India. You should notice on the response, which is made returnable on so and so. Give a date after 4 weeks. Petitioner shall take steps within 2 days for service of notice on the respondent by speed post to the deed. In addition to usual steps, the petitioners shall also take steps by dusty mode for service of notice on the respondent number 3 by routing the process to the registry of the court, and upon service, an affidavit of service shall be filed prior to the next date of listing. Next one. In the next date of listing, the further proceedings in MSC case number 1844 of 2020, pending before the learned member from Motor Accident Claims Tribunal, dash numerical 3, Congo Metro from Gauhati shall remain state. Next one, the petitioner shall produce a certified copy of the order before the said learned tribunal. Bring the order to the notice of the I said learned tribunal. Next one, based on so and so. Give a date after 4 weeks.
Offline.
On a non-hearing day, either Monday, Wednesday, or Friday.
Offline.
Item 7.
Let's see, my lord. My lord, this civil revision petition has been filed challenging the order dated 30/8/2025, passed by the Honorable Court of Civil Judge, my lord. The order is at page number 54, my lord. Order is at page number 69, my lord.
Page number
69, my lord. Annexure 7. By this order, my lord, the cross-examination of the plaintiff witnesses has been closed, my lord.
how many adjournments did you take?
Yes, my lord. In this matter, my lord, the petitioner number 1 is the government high school minor. So the government pleader was conducting the proceeding in the civil court, my lord, and he had taken adjournment for 7 times, my lord, without the knowledge of the petitioner, my lord. And the orders was from page number 54, my lord. Page number 54, my lord. Lordship has got it. On all the occasions, my lord, the Angus counsel had taken time for personal reasons, my lord.
Where is that?
My lord, page number 54. Order dated 2nd of September 2024, my lord.
Page, where are the petitions for adjournment or orders by the what you call the trial court?
My lord,
Where are the petitions or orders of the trial court?
the page number 54, my lord. It's the from petition. The petition starts from page number 13, my lord, annexure 1.
Page number 13.
Yes, my lord, 1-3, my lord, 13, annexure 1. In this, I am the respondent number 1 and 2, my lord.
After 7/1/2025 at page 62,
My lord,
the next date was on 10/3/2024. This order you have not filed. This order until 9/6/2025, any other past you have withheld. Why?
no, no. Okay. Okay.
You have Mr. A. Basumutari.
Yes, my lord.
Heard Mr. A. Basumutari, counsel for the petitioner. As per order dated, order of the trial court dated 7/1/2025, for the next date was fixed on 10/3/2024. However, the orders passed between 10/3/2024 and prior to 9/6/2025 are not enclosed. So accordingly, matter stands adjourned today. The petitioner shall produce the missing order sheets by way of an affidavit. It's list after a week.
My lord, in the meantime, the proceeding may be given.
You don't give copies we take 5 minutes time looking at the documents, each and every order, you're not there. Your explanation is not there. There is no statement in your in this revision petition that cost imposed on 2/9/2024, 7/9/2024, 1/10/2024, 7/1/2025 were deposited. You have two options. Either we adjourn the matter or we dismiss the matter. You elect what do you want.
My lord, then matter will be adjourned for the time.
Item 8,
May I please address?
Yes.
My lordship, petitioner has challenged the order dated 26/2026, annexure 7, page 186, by which the application filed by the petitioner, defendant number 3, and the order 7 rule 11 has been rejected.
Where is the plaint?
Plaint is at page 47, lordship. Prayers of page 59.
And where is this order of 10/6/2008
Lordship, 10/6.
passed in misallocates number?
Yes,
203
yes,
or
page,
2007?
page 100, Lordship, reference as well. Relied on document of the plaintiff, Lordship. Page 100.
But Mr. S. Dekar, I'm counsel for the petitioners. State is the party here, no?
Yes, sir, there is a party, but they are pro forma expert, it was proceeded expert. Pro forma respondent.
Government group is not here. Government group
Singh was present just now.
was there?
Jay Singh was present 2 minutes before. Jaswinder Singh, government employee.
None of them call for the state respondent. State respondent was 63 and 64. Check it out. Next paragraph. Agreed by the order dated 26/2/2026, passed by the learned civil judge within bracket senior division, it was Dibrugarh, in NSJ case number 74 of 2024, arising out of title suit number 33 of 2008, by which the said learned court had refused to stay the suit under order 7 rule 11 within bracket small d of the CPC, was rejected. Next, issue notice returnable on due date after 4 weeks, same day. Extra requisite copy of the application along with enclosures be furnished to the government advocate within 2 days. Extra, the petitioners shall also take steps within 2 days for service of notice on the respondents by speed post with AD. Next paragraph. Till the next returnable date, the further proceedings in statute number 33 of 2008 shall remain state. So it is pending for the court of learned civil judge within bracket senior division, if it was Dibrugarh, shall remain state.
Haliabad. Obliged.
Item 9.
Yes.
Now, in this case, what is happened immediately after the death of accidental death of our daughter, my lord, along with her husband and grandson, my lord, we filed one MSc case here in this Kamrup Metro, my lord, that is pending before this honorable court. Subsequently, what has happened? One of the sister-in-law of our deceased daughter filed 3 MSc cases in the court of Gwalpara, my lord. The court below. All 3 cases, out of 3 cases, in one case has been already settled in respect of the nephew, my lord. Subsequently, what has happened when our daughter's husband case is pending along with our daughter's case pending before the court below at Gwalpara, we have applied. We have come to know that one legal hair certificate submitted by them, and 4 more sister-in-laws are alive there. So they are to be implemented as a party respondent in the landed court below. Because
Just, please tell me again, who died in this accident?
yes, my lord. One, our daughter died in accident, my lord, on 9/10/2017.
Okay. He's a married daughter?
Married daughter. In the year 2018, we filed MSc case because already her, my lord, father-in-law, mother-in-law also expired, my lord. No legal heirs except the sister-in-law and one of brother-in-law alive.
Okay.
During the pendency of the state condition, my lord, kindly peruse your lordship legal hair certificate of our daughters, my lord.
But from the, you
Wait,
you belong to what you call your, from the name is suggestive of the religion. How do you get a right to claim the compensation for a married daughter?
yes, my lord. What is happened when nobody, my lord, no claimants as a legal resident, they also maybe because they are the parents, actual parents. Kindly peruse your lordship page 46.
You don't say that your the relationship of your deceased daughter was estranged from their there was a divorce with her husband and all. That's not your case.
No.
So therefore, how will how will the natural father of the women,
Yes,
married woman, get a right to have a claim made in his name?
my lord, because as nobody except the sister-in-laws are present here, we have applied for because immediately after the death of
No.
all expired, my lord, husband,
Her
grandson, all.
see, her estate will go to her brother-in-law. It will not come back to you.
No,
Unless you show me the right of inheritance.
only sister-in-law all married. One of the sister-in-law filed the case, but not including the other sisters, my lord. Kindly peruse your
It
page
will
46.
be their family dispute.
Yes,
How you are
Lord.
interested?
And they have also not implicated them as a party respondent also.
How
Page
are
40.
you aggrieved?
Lordship,
How are you aggrieved if the sister-in-laws are not a party?
because my lord, I wanted to file one application before the my lord, MSCT Gauhati, my lord. Last page, annexer 8, page 51.
Show me that you are entitled to a share of that deceased lady's estate. You must show your right to have a right in the estate of the deceased lady. Shows that.
Yes, my lord. I filed one application also for impeding her as a party respondent in our MSc case, so that she can reply.
It should not be maintainable.
Then, my lord, I may be allowed to, my lord, take some time, my lord, I place in my case because other nobody are present.
No,
my lord.
that it goes to the insurance benefits. But just because there is nobody is coming, doesn't give you a right to file a case and claim that money.
Well, we are the parents, my lord.
Don't
Yes.
you have a right?
Mother also survived, my lord. Her mother.
It should
And
be
they are
a
also shown to be as a dependent here, my lord, in the MSc
You
case.
have a right.
Here in this case, my lord.
Under the Hindu law, you can show that you have a right.
Yes, my lord.
claim in evidence to be stated.
Sometime maybe even while I, my lord, check the law, my lord. Otherwise, my lord,
Query of the court as to whether the petitioner would inherit any share in the estate or the deceased. Mr. S. Das, and counsel for the petitioner, raised for some time to address the court. According to list,
any that subject to, I don't know.
let us see date, we'll fix it then.
Yes, my lord. 22nd June, my lord. Or before, which,
22nd June, after 1 month.
no, my lord, then, my lord,
So that's simple question.
25 May, 25 May.
25 May. This one 25, 526.
Our
For admission, item 11. Item 11.
Is there any objection to transfer?
Yes, a filed the affidavit in opposition. Your Lordship.
What is your source of income?
She is unemployed.
No. Your source of income?
Uh,
do you do?
My client is actually 75% invalid. He is now unpaid, lying.
It's okay, but
No income
source of
source. No income source. He has been taken care of by unmarried sister and brother. Medical certificate has been annexed with the affidavit in opposition. He was a businessman, Your Lordship. With one time, it was a very he was a very good businessman. Financially, he was very stable. But at present, since last about 1.5 years, Your Lordship, he is not doing anything and dependent upon his unmarried sister. With the permission of my lord, I would beg to defer the opposition counsel. Your Lordship, the respondent number 1, he was having a very good business running at Badatpur area and under Sribhumi district, and he is having his own home, his own house, his ancestor property, and I also beg to differ with my learned opposition counsel is that according to the divorce petition submitted by the respondent before the additional district in session judge Sribhumi, my lord, they have claimed that the respondent suffered from a cardiovascular arrest in the year 2018. That is 6 years ago, Your Lordship. They have filed as an annexure one disability certificate, Your Lordship. I don't know how my learned opposition counsel comes to the conclusion of 75%. Nothing of that sort is written. If she is calculating the point number 1, 2, and 3, then this is beyond the measures of percentile, Your Honor, Your Lordship. And one more thing, Your Lordship, he suffered the cardiovascular arrest in 2018. And today is 26. After 8 years, he must have been cured at some extent. He is subjected to stroke, Your Lordship. One side is totally paralyzed. One side is totally
You
paralyzed.
can't stay silent till the other side counsel is speaking.
I'm sorry.
Extremely sorry.
You were silent when you were speaking. You should show same courtesy here also.
Yes, yes.
Then let us proceed. Please sit down. We'll ask you questions when required.
I'm extremely sorry.
Sit down, please sit down.
Your Lordship, it is 2026 now. Some sort of medical improvement must have happened. But however, my learned opposition counsel have not filed any documents to show such improvement. And they have filed one disability certificate for Form 4, Your Lordship, which is under RPWD Act 2016 is given to someone with specially disabled. Form 2 or 3 are there. Form 2 specially calls for someone who is having paralysis of limbs and in case of blindness. One more thing I would also like to point out, Your Lordship, in page number 5 of the divorce petition, which we have annexed along with our transfer petition, Your Lordship, they have mentioned one thing, that the respondent number 1 could not see, talk, read, and write. But astonishingly, he is filing case without any scribe or agent, without having a legal guardian of his. Before
Which part of the petition is in his handwriting? Which part of the application or his affidavit?
Your Lordship, they have filed one in the transfer petition. Received by us to mail by our learned opposition counsel. It shows Rajoshi Chakraborty, respondent through Debolina advocate. So, Your Lordship, Rajoshi Chakraborty is his signature. He has signed over here. Then how is he appearing before the district and additional district and session just reviewing and saying that he cannot sign the document? And this is an affidavit in opposition, Your Lordship. He must sign as a deponent to file this petition before this court, Your Lordship. I would also like to bring into the notice, Your Lordship, the disability certificate.
So that means if somebody comes and gives a thumb impression in any document, he is neither blind nor disabled and is perfectly fit according to you. He shows any authority on the point.
Yes, Your
If
Lordship.
a person comes to court, gives his thumb impression, his disability certificate vanishes. It
Yes,
can't be
Your-
right. So
absolutely, Your Lordship. In the
shows an authority.
form,
It shows an authority which makes you think that if a disabled person comes and gives thumb impression in court, he is not disabled. Show me an authority.
I'm not saying that. I apologize, Your Lordship. I'm not saying that. I'm just
So
saying
you are
that
saying that he came to court and therefore is not disabled. 70% disability certificate is false. Show us any authority which compels, which makes us take your statement that a person coming to court giving thumb impression is not suffering from his disability.
Your Lordship, I would like to bring into notice, Your Lordship, the disability certificate which was issued to him in 2022.
First of
Here,
all,
he has
answer
signed,
the-
Your Lordship.
answer the court query. You are wanting to answer it or not answering it?
I will answer, Your
Yes,
Lordship.
yes, answer that.
He is authorized to come before this court, Your Lordship.
Yes.
Yes,
And it
Your
destroys his disability certificate.
Absolutely not, Your Lordship.
Okay, then next statement of yours.
Your Lordship, in the page number 38, he had already signed over there in the disability certificate while receiving the disability certificate. And that is in 2022.
Yes. That means the doctors and all, everybody is fabricating this document.
Your Lordship, this is still a matter for evidence has not been taken, Your Lordship. This is still for the trial court to take evidence on this
We
matter.
could have thought otherwise, but your submissions compel us to dismiss your petition. If a person is suffering from 70% disability, you are only at how many kilometers away? 45, 50 kilometers away. You can definitely transfer, go there and attend. If you want, you can raise what you call the bus fare bill before the court. This is a submission we can't entertain. You are making a collateral challenge to a doctor's medical certificate under Form 4. You look at the certificate at page 37 and 38.
Yes, Your Lordship.
37 is locomotor disability 40%.
Yes, Your Lordship.
Have you given care to any person who is suffering 40% adult person who is suffering from 40% locomotor disability? Have you personally given any care to any person adult who is suffering from 40% disability. Have you done it personally?
No, your lordship.
Have you seen any person with 40% locomotor disability?
I've seen someone, yes.
You have seen,
Yes, your lordship.
and you feel that this with 40% locomotor disability is a healthy person.
No, your lordship,
Then-
definitely not.
And second is 40% blind. A person suffers stroke, has 40% disability, gets 40% blindness. You think he is healthy?
No, your lordship.
Then come to next page, page 39. The doctor gives the consolidated disability of 71%, and that is the effective disability of the person.
39, we have not received 39.
Page 38, first line is total 71%. And you think a person with locomotor disability with total disability of 71% is a healthy person?
No, your lordship.
No. So please, before next time when you make submissions like that, disputing the disability of a disabled person,
Yes, your
please
lordship.
try to give care and then tell us. You don't even know the pain which person suffers. A healthy person who suffers suddenly a disability of paralysis. You say that your husband was a good businessman. He suffers 71% disability because of a paralysis stroke. And you think it is fun that he will not object to this transfer petition? You can't travel 70 kilometers or 50 kilometers from Sribhumi to Karimganj. So Karimganj to which place is your residence?
Kachar, your lordship.
Kachar. You give your city bus certificate. He will give you the fare.
Yes, your
You
lordship.
dismiss your application.
Much obliged.
Have some empathy for those people who are disabled. They are not getting a disability certificate just for nothing. Try to give a care for 7 days to a person with 40% locomotor disability. You will understand the world, what tough the world is about. They are not given. Don't tell us, because I have given care, not for 1 day.
I
I
apologize,
have
your
given
lordship.
care like that to my parents who were totally bedridden for 9 years. Without keeping a aid, though I am entitled to keep one, we have taken care of my parents with these disabilities for 9 years without giving a caretaker. Without a caretaker, we have given that care to my parents. Don't make us say that. These are very personal issues, which I have said there.
I apologize.
You don't
for
even
this.
know that amount of disability they have, the amount of care they require. You have not seen those things. Therefore, don't make us change our view towards the law because of that.
I apologize, your lordship.
You can contest, that is okay, but you are in an affidavit which has been filed. You are making a collateral challenge to a doctor's certificate. Are you aware of the validity of the doctor's certificate under the PWD Act?
I mean,
Have you challenged that certificate anywhere? Do you dispute the authority of the Joint Director of Health Services who has given this certificate? And you think that this 2022 certificate was obtained to make out a ground for opposing this application filed in 2025? In 2022, your husband will not go and get a certificate to oppose your application in 2025. And which authority makes you state that once a person has suffered 70% disability, in passage of 5 years' time, he will be okay. 3 years' time, he will be okay. Which medical books have you read? Don't make such summations. You're dismissing it. I'm sorry I expressed some statements which are not, it's not my personal matter, but I have
I mean, your lordship.
been compelled to say that because the care, you don't even know that care is required. I'm sorry for that.
I applied,
Good.
Your Lordship.
Ms. S. Bhattacharjee, learned counsel for the petitioner. Also heard Miss. Your name?
D. S. Gaur, Your Lordship.
S. Kaur,
Yes, Your Lordship.
learned counsel for the respondent.
No,
Oh, you are the petitioner, I'm sorry. Miss S. Kaur, learned counsel for the petitioner, and Miss
D. Chaudhary.
B. Chaudhary, learned counsel for the respondent. Next one. By filing this transfer petition under section 24 of the CPC, the petitioner, who is the estranged wife of the respondent, is seeking transfer of the proceedings of TS within bracket divorce, bracket close, 35 or 2025, pending before the Court of Learned Additional District and District Judge, Sri Bhumi, to Family Court at Silchar, Kachar. So the case projected by the petitioner is that she is unemployed, currently suffering from tuberculosis, and due to non-payment of financial aid and willful desertion by the respondent, is physically unwell and is unable to continue her treatment, and therefore is prayed for transfer of the said proceedings. The parties have a son out of the wedlock. Who is the custodian, who is having the custody of the child?
Mother, Your Lordship.
Okay, and the petitioner is having to take care of the minor child born on 6/11/2014. Where is the statement that he is not paying any, you have paid for maintenance and there is an order of the
Yes,
court and you have not been paid?
Yes,
Where
Your
is that?
Lordship. Yes, Your Lordship.
Where is that statement?
Petition is,
Where is the statement that the court ordered maintenance and you did not, he is not paying you?
Your Lordship, in point number 4, number 10, Roman 10,
Then,
page number 6, Your Lordship.
and where is this order referred to? Maintenance. Yes, and what about maintenance? You are not paying that maintenance?
Your Lordship, so far my knowledge goes, as I am not looking after this case, this is pending before this honorable court only. Against that order, maintenance order, perhaps
There is no stay order, Your Lordship, and they are not appearing at any date, not paying a single penny, Your Lordship.
Not appearing
They are
in the,
not appearing at any date. They're just seeking adjournment, Your Lordship.
in the High Court.
No, not here, at the court of the principal judge, Kachar. And there is no stay order given by this honorable court as well, Your Lordship.
In that criminal petition.
Yes, Your Lordship.
Then you take instructions, you deposit 10,000 rupees as cost for the petitioner to travel to the place to contest the proceeding. You take instructions, we'll take it up at 2. 10,000 immediate costs and payment of the maintenance. When will it start?
Yes, sir. Not sure.
Your
Take it up
Lordship,
at 2 o'clock.
yes, I will definitely, Your
Get an
Lordship, but
instruction.
Your Lordship, his condition is really not good.
Let them place the point before the court, civil court at.
We'll take that. We'll request the registry to list both the matters before us
Your Lordship.
We can extend that jurisdiction. Criminal petition also we can track
Yes,
it
yes.
because of this pendency of this divorce petition. This 125 arises out of this divorce petition. We have jurisdiction, don't worry, we'll call for that if required.
Yes, Your Lordship.
At 2 o'clock, tell us by when you are making that payment.
Yes, sir.
Because without the payment, we may allow this application. So despite your disability, we'll allow the application.
At 2, Your Lordship?
At
Today
2.
At
At 2.
Okay.
Much obliged, Your Lordship.
Take a break and come back.
Item 12 with 13.
Meet resolution.
Yes.
My lord, these two religion traditions are identical in nature, identical on facts also. An application was filed by the defendant, my lord, who are the petitioners in this case, for rejection of the plaint, and that was rejected by the learned trial court. Against that order, my lord, the petitioners are before your lordship. And there is an interim order. Now, my lord, the case of the petitioner is that the plaintiff is a builder, and the predecessor in the interest of the, my lord, present petitioners were the defendants. He was the, my lord, owner of a plot of land, and that there was an agreement regarding that plot of land, and the plaintiff's present respondent, my lord, is the builder. Now, the application was filed for rejection of the claim primarily on two grounds. Firstly,
Just a moment, Mr.
My lord.
Chaudhary. This agreement of 6297 of 2019 is what agreement? The development agreement.
development agreement, which your lordship finds at page 45.
No, I am asking this question because we have come to page 37.
My lord.
Page 37, first pair is that the development agreement is subsisting, that is 2458 of 18.
My lord.
Second pair is declaring the registered deed so and so, cancelling the registered power attorney being so and so
My lord.
is illegal.
My lord.
That
That
is
was the
cancellation by between whom? With the same parties.
same party.
Can we see that document? Even if it is not annexed, do you have the document?
Second document is only, the registered deed of power of attorney.
Cancellation deed. The agreement is the
I think that
first
should be
annexure.
part of the plaint, my lord.
Development agreement is available.
My lord.
Document 1 and 2, I think, that's page.
Page 71.
71 is general power attorney, I believe.
My lord. 71, 69, 70. General power of attorney.
This is the cancellation.
And you can take. You can it to date.
Page 82, you give a notice of proposed cancellation. Page 82.
My lord.
And page 70, page 96 is the cancellation of power of attorney.
My lord.
But where is this cancelling the? Oh, achha, B, I'm sorry, I'm wrongly reading it. Page 37 is cancellation of registered, that power of attorney.
Right.
Okay, I'm sorry, I was wrongly reading it. Okay. Yes, now please proceed.
No, your lordship, will you kindly
There will be prayers in the plain. Your worship has already, my lord, read prayer 1 and B. Page 37. Prayer C is alternatively a decree of realization of an amount of rupees 17 lakhs with interest at the rate of 24% since the date of the agreement till realization of the same. In the event the plaintiff is found not entitled for specific purpose of contract, and then your worship may also come to page 39, my lord. Prayer G. A decree declaring that the plaintiff is entitled to receive liquidated damages to the tune of rupees 1 crore with interest thereupon. Now, my lord, these prayers are relevant in the sense that, my lord, this shows that the my lord, relief which the plaintiff has claimed, my lord, can be duly compensated in terms of money. Yes. Now, my lord, the grounds that we have taken primarily is that, my lord, the agreement which is at page 45, specific purpose of which is, my lord, sought in this, my lord, in the suit. This is, my lord, very vague. I'll come to, my lord, your lordship, who will need to read the clauses of the agreement. And the law is very clear, my lord. That has been discussed by the learned trial court while rejecting my petition. May I read the impugn order, my lord, before going into the details of the agreement? Impugn order, your lordship finds at page 190. And the findings are at page 193. The other cited, my lord, resolution are regarding, my lord, what is claimed, my lord, that the plaintiff is, my lord, developer, that there was an agreement, the defendant's predecessor in interest was a landowner, and they
But
entered.
how will this, how will, under that facts you have said, and the prayer read, how the plaintiff is barred by any law, order 7 to 11?
Yes, my lord, that is what, my lord, I am trying to impress upon your lordship concerning the, my lord, finding, because 14(3)(c) of the specific relief act, my lord, it stipulates some conditions which have to be fulfilled for specific purpose of a contract. Okay, from here. Your lordship has to, my lord, will kindly take note of one fact, my lord. The 14(c), section 14 was amended on, my lord, in 2018, and the new amendment came into force from 1st of October 2018. And the agreement, specific purpose of which is sought, my lord, that was executed on 28th of February 2018. So that is prior in time to the amendment, and therefore, my lord, pre-amended provision will be applicable.
When agreement is dated
28th of February 2018. And
Yes.
the amendment of 2018 came into force on 1/10/2018. Therefore, my lord, the provision of section 14 has to be read, my lord, pre-amended provision.
Yes.
May I read that provision, my lord? Contract not specifically enforceable. The following contracts cannot be specifically enforced. A contract for non-performance of which compensation in money is an adequate relief. B, contract which runs into such minute and numerous details or which is so dependent on the personal qualification or and violation of the parties or otherwise from its nature is such that the court cannot enforce specific performance of its material terms. A contract which is in nature determinable or contract of performance which involves a performance of a continuous duty which the court cannot supervise, save as provided by Arbitration Act so and so. No contract to refer to present or future differences to arbitration shall be specifically enforced, but if any person who has made such a contract other than an arbitration agreement to which the provision of the said act apply and has refused to perform it, sues in respect of such subject which has contracted, this is not relevant. Then 3 is important. Notwithstanding anything contained in clause A or clause C or clause D, because clause A is important, my lord, a contract for non-performance of which compensation in money is an adequate relief. So notwithstanding anything in A or C or D of subsection 1, the court may enforce specific performance of in the following cases. A, where the suit is for enforcement of contract to execute a mortgage, this is not relevant. 2, to take up and pay for debenture of a company, not relevant. B, where the suit is for the execution of a formal decree, not relevant. C is the relevant one. Where the suit is for enforcement of a contract for the construction of any building or the execution of any other work on land, provided that the following conditions are fulfilled, namely, 1, the building or other work is described in the contract in terms sufficiently precise to enable the court to determine the exact nature of the building or work. 2, the plaintiff has a substantial interest in the performance of the contract, and the interest is of such nature that the compensation in money for non-performance of the contract is not an adequate relief. And C, the defendant has, in pursuance of the contract, obtained possession of the whole or any part of the land on which the building is to be constructed or other works is to be executed. My lord, perhaps the amendment was necessary because of, my lord, clause C3, where it says, my lord, the defendant in pursuance of the contract obtained possession of the whole land. So, my lord, defendant is now here, it is supposed to be the, my lord, builder. But here on facts, my lord, the builder has not got the possession of the land. That is an admitted position. Now, my lord, these two conditions, 1 and 2 and also 3, these are not satisfied in this case. For that, my lord, I'll have to take your lordship to the agreement. Now, the reasoning that has been given by the learned trial court, your lordship may also like to see, because, my lord, there is a judgment of the Supreme Court on which the learned trial court has relied. And, my lord, in my humble submission, the ratio of the case has not been properly understood by the learned trial court. May I take your lordship to the, my lord, the findings that has been recorded by the learned trial court in the interim order.
Yes.
The reasonings given are, my lord, at page 193. May I read, my lord? Here is the materials on record, 3rd paragraph. The defendants have prayed for rejection of the claim on 2 grounds, that is, the suit is barred by law and no cause of action. Taking up the point that the suit is barred under section 14(3)(c) of the Specific Relief Act, it is seen that the plaintiff has filed the instant suit for declaration, cancellation of deed, and for permanent and mandatory injunction. From the averments made in the plain, it is seen that the plaintiff has challenged the deed of cancellation of power of attorney dated 28 to 2018, by which the predecessor in interest of the defendants cancel the deed of attorney executed in favor of the plaintiff. It is about that the predecessor in interest of the defendant executed two registered deeds of agreement, that is deed number so and so, dated 28 to 2018 with respect to 4 katha 13 lectures, 13.5 lectures of land, and deed number 3861 of 2018 dated 27/3/2018 with respect to 1 katha 5 lectures of land for development of state lands belonging to the predecessor in interest of the defendants. The land measuring 4 katha 13.5 lectures is the suit land. It is also averred that the plaintiff developer paid a sum of rupees 70 lakhs to the predecessors in the interest of the defendants pursuant to execution of the deed number so and so dated 28 to 2018 with respect to 4 katha 13.5 lectures of land. In section 14 of the specific relief act as it stands today, my lord, means that, my lord, after amendment. So, my lord, the subsequent provision has been taken note of. Now, my lord, noting that, my lord, thereafter, that is 197, because, my lord, the post amendment, my lord, that provision will not get attracted in this case, although, my lord, that has been quoted entirely. Then, my lord, the pre-amended act has also been discussed, my lord. 195, second paragraph. Prior to amendment of Act of 2018, Section 14 of the Specific Relief Act as laid down as following. Then, my lord, that has been quoted. Your lordship has already read that. Then, my lord, the discussion, my lord. After that, my lord, as I have already my lord, submitted before lordship, clause 3, 1, 2, and 3 are not satisfied. Then next paragraph, my lord, the findings. Next page 198. It will be seen that 14(3)(c) of the Act, as it stood earlier, a suit for specific purpose of a development agreement was maintainable provided it fulfilled the three conditions. A literal interpretation of Section 14(3)(c) Roman 3 would show that a developer could not file a suit for specific performance as plaintiff. This effect was significantly altered by the Supreme Court's interpretation in the case of Sushil Kumar Agarwal versus Meenakshi Sadhu. The court adopted a purposive interpretation, ruling that the section did not automatically bar a developer from seeking relief, seeking specific performance. The Supreme Court held that the issue before this court is whether Section 14(3)(c) Roman 3 is a bar to a suit by a developer for specific performance of a development agreement between himself and the owner of the property. The condition under Section 14(3)(c) Roman 3 is that the defendant has, by virtue of the agreement, obtained possession of the whole or any part of the land on which the building is to be constructed. If the rule of literal interpretation is adopted to interpret Section 14(3)(c)(3), it would lead to a situation where a suit for specific performance can only be instituted at the behest of the owner against the developer, denying the benefit of the provision to the developer despite an interest in the property having been created. This anomaly is created by the use of the word the defendant has, by virtue of the agreement, obtained possession of the whole or any part of the land. In Section 14(3)(c)(3), under a development agreement, an interest in the property may have been created in favor of the developer. If the developer is the plaintiff and the suit is against the owner, strictly applied, clause 3 would require that the defendant should have obtained possession under the agreement. In such a case, if the developer files a suit for specific performance against the owner, and the owner is in possession of the land by virtue of a lawful title, the defendant, that is the owner, cannot be said to have obtained possession of the land by way of the agreement. This would lead to an anomalous situation where the condition in section 14(3)(c)(3) would not be fulfilled in the case of a suit by a developer. Application of literal rule of interpretation to section 14(3)(c)(3) would lead to an absurdity, and it would be inconsistent with the intent of the Act. 24. The condition that should be present to justify a departure from the plain words of any statute have been elucidated in Justice G.P. Singh's Treatise of Principles of Statutory Interpretation while discussing the decision of Honorable Lord so-and-so. A court would only be justified in departing from the plain words of the statute when it is satisfied that there is a clear and gross balance of an anomaly. 2. Parliament, the legislative promoters, and the draftsmen could not have envisaged such an anomaly and could not have been prepared to accept it in the interest of the supervening legislative objective. 3. The anomaly can be obviated without detriment to such a legislative objective. And 4. The language of the statute is susceptible of the modification required to obviate the anomaly. The principle has been also adverted to in Maxwell on interpretation of statutes that has been quoted, where the language of a statute in its ordinary meaning and grammatical construction leads to a manifest contradiction of the apparent purpose of the enactment, or to some inconvenience or absurdity, hardship or injustice presumably not intended, a construction may be put upon it which modifies the meaning of the words and even the structure of the sentence. By giving a purposive interpretation of section 14(3)(c) Roman 3 of the anomaly and absurdity created by the third condition, will have no applicability in a situation where the developer who has an interest in the property brings a suit for specific performance against the owner. So, my lord, possession part has been done away with by this judgment. Then, my lord, this is important. The developer will have to satisfy two conditions laid out in subclause 1 and 2 of section 14(3)(c) for the suit for specific performance to be maintainable against the owner. This will ensure that both the owners and the developers can avail of the remedy of specific performance under the Act. A suit for specific performance filed by the developer would then be maintainable whether the specific performance should be in the facts of a case be granted in a separate matter bearing on the discretion of the court. In view of the above principle, it is clear that section 14 of the Specific Relief Act, even as it stood earlier, did not bar developer from seeking specific performance of development agreement against the owner of the property. Neither does section 14 as it stands today after the amendment. However, the question whether specific performance can be granted will be decided after taking into consideration the materials on record at the time of judgment. With regard to the point that the suit lacks cause of action, it is seen that the petitioner itself does not state how the suit lacks cause of action. Be that as it may, the pleading and materials on record divulge facts which give rise to cause of action. In view of the above, the petition is rejected. Now, my lord, while deciding this, that possession part apart, my lord, which has been obliterated by the Supreme Court judgment, whether, my lord, the section, my lord, subsection 1 and 2 of clause 14(c) has been fulfilled or not, that has not been, my lord, discussed, and my lord urge your lordship to examine that whether, my lord, these two conditions are satisfied. At the cost of repetition, my lord, I'll need to read the two provisions again.
You're saying 3D,
My lord.
14, or 14(8)(d).
No, my lord, I am on 14(3)(c) 1 and 2.
3C1 and
1 and 2, those are to be fulfilled, my lord. That is what the Supreme Court says. That part has not been, my lord, discussed. Whether those conditions are fulfilled or not. that is where the, my lord, the learned, my lord, trial court has committed error. Now, these two conditions, my lord, if I may read again, my lord, clause C, where the suit is for enforcement of a contract for the construction of any building or execution of any work on land, provided that the following conditions are fulfilled, namely, the building or other works is described in the contract in terms sufficiently precise to enable the court to determine the exact nature and building of the work. My lord, I'll show from the, my lord, agreement. We have to read the clauses of the agreement to show that, my lord, the this specific, my lord, nature of construction.
Precise point. That is the precise point.
That is
You
point,
see-
and also, my lord,
No, not that.
my lord,
The question which I am posing, that is the precise point.
my lord.
You see, when deciding order 7 rule 11, can the court give a finding of fact with regard to the nature of the conditions fulfilled, one building or other work described sufficiently precise to enable the court to determine the exact nature of the building or work? The plaintiff has substantial interest in performance of the contract and interest of such person. If the condition of money is not so and so. This is a dependent on evidence. How can the court at this stage?
My lord,
order
my lord, by submission, will read that provision, order 7 rule 11, my lord. If, my lord, at this stage of filing an application for rejection of the claim, my lord, that is not, my lord, decided, then what is the purpose of the existence of that particular provision in the act, my lord? That is what I ask myself, my lord. If your lordship comes to order 7 rule 11, my lord, may I read that, my lord? Rejection of claim.
Yes, please.
The claim shall be rejected in the following cases: where it does not disclose a cause of action; B, where the relief claimed is undervalued and the plaintiff, on being required by the court to correct the valuation within a time to be fixed by the court, fails to do so; where the relief claim is properly valued but the plaintiff is returned upon proper paper insufficiently stamped and the plaintiff, on being required by the court to supply the requisite stamp paper within the time to be fixed by the court, fails to do so; where the suit appears from the statement of the claim to be barred by any law. Now, my lord, whether it is barred by any law, my lord, for that, my lord, the court has to, my lord, examine the contents of the agreement, whether that can be specifically performed, my lord. Here is a case where, my lord, even the final relief cannot be granted. So that will be a waste of time, of the judicial time, my lord, of the court. And it does not bar, my lord, otherwise this provision, my lord, B11D would not have been there, my lord. So, my lord, in order to determine whether, my lord, from the statements in the claim to be barred by any law. So, my lord, to be barred by any law is that, my lord, 14(3)(c), my lord, whether the conditions are specific or is so vague that it cannot be specifically enforced. Therefore, my lord, we'll need to go through the process of the agreement. And also, my lord, on the rejection of claims and the provision of CPC, there are some case laws I may refer to. Well, this matter has come up for admission today. May I pray that, my lord, it will be admitted and fixed for final hearing any day convenient to your lordship, my lord?
But they can complete it because this suit of 2021. The only fact is that we have to examine whether the clauses disclose any cause of action.
Yes, cause of action is there, maybe there, my lord. But then, my lord, the provisions in the agreement are so vague, also the vagueness, that, my lord, it cannot be executed. If it cannot be executed, what is the point of going into the trial? That is one. And, my lord, I have not raised the point, my lord, that it is the adequate compensation. He has in the plaintiff itself, my lord, the compensation has been sought. Because the plaintiff himself is not sure that he will get the, my lord, he can get a degree of, my lord, specific performance. That's why, my lord, he has prayed for the, my lord, compensation and also, my lord, damages, liquidated damages.
See, the answer is very simple. Even if we don't go through anything else, one of the relief is that he needs to do performance of contract. It is subsisting. That is what he is wanting.
I didn't get your lordship, my lord.
you look at the prayer,
My lord.
it says that the agreement is subsisting, legal, valid and binding. That's the first prayer.
Yes.
Second is, second we can omit for the time being. C is alternative prayer for 17 lakh rupees.
My lord.
And third is compensation for 1 crore. Now, you'll have to satisfy us that while making a prayer for rejection of plaint, only one prayer can be rejected. Because if the other alternative remedy is available to him, for that this would still be enforceable or adjudicatable.
My lord, my submission to your lordship that, my lord, you have yourself said that I want that 17 lakhs back.
So the
And also, my
court
lord,
may grant an alternative remedy.
liquidated
But you see,
damages.
how can the plaint be rejected when the prayer for money is there? We accept everything you say.
My lord, the everything is, my lord, in the suit is, my lord, the basis of the suit is that agreement, my lord.
We understand, but let us say we accept everything what you say.
My lord.
Even then, whether the prayer for money can be said to be barred for any law in the time being, because
My
if the
lord,
prayer
in-
is a multiple
My
prayer.
lord, in the event, my lord, the court finds that the contract is not specifically enforceable, my lord, other
No,
prayers
once the
become
plaint is
redundant.
rejected, that goes, and it becomes a decree is barred from making any further suit for that time. If the plaint is rejected on the ground of being barred by law,
My lord.
then the second suit will not be maintainable.
Or, my lord, the claiming damages or, my lord, compensation. My lord, if the agreement is, my lord, agreement is not executable, my lord, it cannot be enforced. Then on the basis of that agreement, how other reliefs can be granted, my lord? That is the question that comes to my mind. My lord.
No, but you see, it's an alternative remedy. He may say that, well, I don't want to perform. Now we did a decree because we entered into an agreement.
The
of-
prayer is that in the event the court finds that this, my lord,
It's an alternative. So how can we say that the money claim would not be maintainable?
my lord, my submission is that, my lord, if the contract cannot be specifically enforced, any right that may have accrued or you claim to have accrued, that of the prayer also cannot be granted, my lord. Therefore, my lord, it is necessary that your lordship will go through the clauses of the agreement, the vagueness of the agreement. Unless your lordship, my lord, goes through the clauses of the
I'm
agreement.
not saying we're not going into it, but it doesn't serve a purpose. The reason is twofold. Number one I have already discussed. The second is that can the, at this stage of Order 711, we can have a interpretation of all the clauses of the agreement and then say that it is vague. You see, this whether it is vague or not will only be dependent on the nature of evidence placed.
Nature of evidence.
Nature of evidence which is placed in court. The corollary is that what makes an agreement. All contracts are not agreements, but all agreements are contracts.
My lord.
To prove a contract, you may take external aids also to show that this is not vague, this is an agreed, what you call, agreement. It take the vaguest possible agreement. It says that I borrow money from you. If you fail to make payment, you'll have to send me to moon. It's physically impossible to perform that. But why if somebody comes and I am good in giving very horrible examples. I am giving one. Now the other man comes and says, "Look, I can send him because I am a good friend of one of the big industrialists in the US who went to space. I can send him to moon. It will cost me enormous, but yes, I am in a capacity to send him."
My lord, may I give a little idea about the vagueness, my lord?
Yes, we'll see that agreement.
That's all I was imploring that your lordship will go through the agreement, my lord.
So we'll see, you point out what is the wrong, because reading alone, I won't understand anything. I need the assistance, I will assistance of both of you to read that agreement.
Because, my lord, unless your lordship goes through the agreement and takes a view whether, my lord, the requirement of the C1 has been fulfilled or not, my lord, then only a decision.
So we are ready to go into it. If you want to take it up, not today, but tomorrow, day after tomorrow, or Thursday, we'll do it subject to what Mr. Ali says.
So,
Because in 2021 suit, we are not planning to give very long adjournment or to raise this matter for hearing in usual courts.
that will be contrary to his interest because there is a stay order, my lord.
That's why.
I don't want any long
Either
day.
tomorrow or Thursday, we can take it up at your convenience. Subject to both of you agree to a date.
Incomplete na kora.
Your short matter, your lordship, and I think he has actually completed his argument.
That is
My
why
argument, your lordship, why
You
what's the
see,
argument, your lordship,
that
merit
is the
cannot
beauty
be,
of a lawyer in practice.
question is, your lordship, only.
The argument will always be that I may be wrong, but I am always right. And I have to hear,
No, my argument, your lordship, a person cannot be non-suited, your lordship.
we don't know.
That it will go,
You see,
it will
when I-
vary, your lordship. It is
Mr.
just
Ali,
an argument.
Mr. Ali, when
Let him show, your lordship, under order 7, rule 11, A and D, your lordship. that it
Mr. Ali, you have heard him. He is already arguing that.
Yes, your lordship.
So
It is not such long matter, your lordship. It can be confined. Clause A and clause D,
that
your
is
lordship.
your perspective. That will come only when Mr.
And let it show, your lordship, from the
Mr.
plane.
Ali, please try to understand. Now Mr. Chaudhary is on legs. We can't hear you when he is on legs. So therefore, the issue is, you want to do it today, we take it up today. You want to do it tomorrow or on Thursday, we'll take it up on
Matter
that
may
day.
be kept parted, your lordship.
No partner business.
This is matter, your lordship, it can be disposed of at this stage, your lordship.
That's
Because,
okay, but only when Mr. Chaudhary. would
because
complete-
my money as well as
Mr. Ali, we are
other.
not hearing you right now. We're just asking for your convenience. You want the hearing to take place now, or you want it to be taken up tomorrow or on Thursday?
Yes,
At your convenience.
second,
Thursday will be convenient for me, my lord. Because your lordship has already heard part of the matter. Thursday, my lord. Today is
Yes.
Monday.
আৰু ক'ব বাকী আছে তোমাক
No, আগতে আপোনাৰ এগ্ৰিমেণ্টখন বঢ়াম নহয়, যি এগ্ৰিমেণ্ট বনাইছে আপুনি মোক ঠগাইছে।
সেইটো ট্ৰায়েলত তুমি হেৰি কৰিবা, ঠগোৱাটো প্ৰুফ কৰিবা।
I'm sorry, man.
You'll prove it before trial court.
I'm sure that there is no mutuality also. Anyway, madam,
And the Supreme Court says also roving inquiry is not possible.
this is not.
Roving should not be there.
That Mr.
It
Ali,
is explicit.
Mr. Ali, that would come only when he start hearing you. At this stage, we can't stop Mr. Chaudhary and then say that, well, we start hearing the
Now,
respondent.
if somebody, your lordship, hears the facts and the other things, you also go on arguing, your lordship. Goes on arguing. This is,
Mr.
your
Ali,
lordship is not.
Mr. Ali, we can tell you one thing. Please ponder and then respond. You see, if we do all the hard work of reading and making up our mind what the matter is about, please tell us, is it required to hear any counsel?
Follow Thursday, your lordship.
Because that is why you see, that is why I give opportunity to both sides to make an argument. Even if I am satisfied with one point raised, but if I don't give the other side a chance to make a submission, it would be unfair. Second is, there may not be many stout lawyers like you who can argue the best point first. There may be a young junior who would require the best point will come in the 7th or 8th submission. So if we start rejecting the argument now, having a preconceived mind, it would not be good for the bar. I can be well prepared. If you have any doubt, you can expel that doubt. I can be well prepared. Day after Thursday? What says it presented? As the connected suit is of the year 2021. We propose to hear the matter in the adversary stage. Next, this long Thursday. That will be. Putting the.
Lordship, it can be taken up at 2.
You just make a prayer, on the morning you can make a prayer, will accommodate. Because I don't want to
remain busy in the
No,
morning.
because those things I don't want to put in the order at 2 o'clock or 3
Right.
o'clock. We don't know what happens at 2 o'clock.
Maybe court may be free before that also.
No, we don't know. You see, the, what you call, there are several matters which in the previous division bench board, maybe a parted matter which is fixed.
Your Lordship
There
may
may be a
fix this,
special bench.
email or your Lordship may make it court-heard one.
No, that is a difficult thing. But then I have to carry everything.
Lordship,
in head.
hard it, your Lordship has hard it,
Anyway, my,
But I don't want to keep anything on head. If I keep it parted, then I'll have to keep it in my head. That creates more difficulties.
my lord, what
Mr.
happens,
Ali.
it is always a pleasure and privilege to my lord appear before.
No,
Lordship,
no, 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 no. That's not the point. It's,
My lord,
you have an erudite statement and you can, you can make your point to any court, even Mr. Ali, but the point is not that. As a parted matter, then I carry it on my head.
my lord.
That's very difficult.
Very well.
Sometimes whatever in your Lordship, if it is listed in some other court, then this time it will be listed there.
That we don't know. That's why the
That's
difficulty.
why to save this time, your
My-
Lordship, whatever my life,
We don't know.
for such a long.
Hello.
time.
Something which is
That
beyond
can
my
be saved.
control.
Highly applied.
Cutting at 2.
हो जाएगा ना, किसी को पता है?
Locomotor disability and there's a word, I'll give it later. Suffering from 40%, you get. I'll read up later. Sorry, 40%? The first is locomotor disability 40%. And number two, ITBRPO of right eye 30% with partial optical atrophy, OPTIC, optic atrophy, ATROPHY. In the left eye with deficient OSL at 40%. And the total disability is assessed by the Joint Director of Health Services, Karimganj at 71%. In the disability certificate issued under Form 4, under Rule 4 of the Persons with Disability Act, next one. It's the same thing. It is also submitted that the distance between the two places where the case is sought to be transferred is very small, and the daily expenses would not exceed ₹70, whereas the respondent has assessed the financial capacity of the petitioner on merely on the ground that the petitioner would approach this court by engaging counsel and filing this application. Next one. It may be stated that few other submissions were made by the learned counsel for both sides, which relates to merit of the pending litigation between the parties, and therefore the court does not deem it appropriate to record the same or to give any opinion thereon, as it could be best decided by the learned trial court. Next paragraph. The only issue which arises before the court is as to whether it would be appropriate to exercise jurisdiction under section 24 of the Civil Procedure Code to transfer the proceedings from Karimganj in the district of Sribhumi to, that city is still Karimganj or it is Sribhumi? Sribhumi, okay, from Sribhumi to Kachar. Next paragraph. The matter was called in the first half, and the court desired that the learned counsel for the respondent take instructions from the respondent as to whether he is ready and willing to pay the maintenance. Full stop. In this regard, the matter was taken up again in the second half, and upon instructions, the learned counsel for the respondent has submitted that she has no instructions regarding the payment of maintenance. Our comment is submitted that the issue regarding maintenance is pending for adjudication before this court in what is the criminal petition number 63? Where is that number?
2024. 68, 2024.
Criminal revision.
Criminal petition.
Criminal petition number
68, 2020.
68 of 2024. So it is also submitted that as per her instructions, the notice in the said criminal petition has been duly served on the petitioner on
18/3/2024 note is that service is complete.
okay, which appears from the office note dated
18/3/2000. I have screenshot, your lordship. I'm just reading
this will
out.
just tell us the date
18/3/2024.
18/3/2024. So how it is submitted that the petitioner has not yet appeared despite due service of notice.
Your lordship, we have filed our wakalatnama in this case, your lordship. We had already filed our wakalatnama.
File of them. So in this case, the learned counsel for the petitioner submitted that that the petitioner has already filed a wakalatnama in that matter. Next, be that as it may, as it appears that the petitioner is not being paid any maintenance till date, and she's also the caregiver to the minor child of the parties. That being the position from the balance of skills in favor of the petitioner. Next paragraph. The plea taken by the respondent that the financial capacity of the petitioner was doubted on account of the fact that the petitioner has approached this court is not a justifiable ground for the court to presume that the petitioner has all the resources to contest the proceedings, though the distance between the two courts is not very far off. The condition of health projected by the petitioner, coupled with the fact that she is also the caregiver to the minor child, born on 6/11/2014, and non-payment of any maintenance, either interim or lump sum alimony, is entitled the court to transfer the proceedings of case as in a divorce 85 of 2025 from the Court of Learned Additional District Judge Sri Bhumi to the Family Court, Discharge of Heart. Next paragraph. Accordingly, comment is provided as follows. Number one, that on a certified copy of this order being produced by the petitioner or the exchange, the defendant in the said suit, the Learned Additional District Judge, Sri Bhumi, shall transfer the proceedings to the Family Court, Number two, before transferring the proceedings to the said Learned Court, the Learned District Judge, Sri Bhumi, shall also provide a date for appearance of the parties before the transferee court, giving at least 15 days time to the parties to appear before the transferee court. Next paragraph. As both sides are duly represented before this court, both sides are directed to appear before the transferee court on such date as will be provided by the Learned Additional District Judge, Sri Bhumi. Next paragraph. We go to main paragraph. matter stands, the application stands allowed with no orders to post. As well, before parting with the records, it is clarified that this court has not entered into the merit of the case of the parties, and therefore none of the observations made herein shall influence the trial court.
May I be fair? Your lordship, otherwise it's okay, your lordship. The problem is that family court requires personal appearance, your lordship. This is the only problem.
That you'll have to, what you call, file an application, appropriate application before the.
Amicus curiae application may be given, but in case of evidence or that a party's appearance is.
That we don't know.
Your lordship. And
We
this is
can't
the
regulate
otherwise,
we can't regulate the entire proceedings from here. We can't give a, what you call, directions to the effect that as if we are taking over the proceedings and the trial court will proceed as per the dictates of the court. No,
but in your
trial
lordship,
court will have full freedom.
but your lordship being Sribhumi, your lordship, personal appearance is not necessary. So it's not mandatory that.
You see, you can't have a cake and eat it too. We give you an option. And if we can't have it more.
Actually, his sister she's also practicing lawyer, but she's a very new, your lordship. That's why she can manage the legal proceedings. As because my client there's no required to pay money for fees, so official.
I don't know about others, but one of my erstwhile friend in the profession, when I was there, standing where you are, is a few lawyers are here also. And even in the first day of practice, we were afraid of them. Mr. Chakravarti is sitting behind. You have not seen him as an adversary. Even in the first day in his profession, he was able to do wonders. So it's not dependent on what if the lawyer is a junior or a senior. We can't have that assessment. The court can only make an assessment if somebody deserves to be given the shoulder with the ground of a senior. Otherwise, professional assessment of a lawyer we can't make. We are too small to do that assessment. I can't say whether one day of practice is good or bad. Can't say that. But if you are, yes, you'll have to make arrangements. You can't have a cake and eat it too. You don't want a transfer, you don't make, you are not wanting to make payment of the maintenance. Once you make that maintenance, we would have thought otherwise. He's taking care of your child.
Much obliged.
Item 27.
May I please, your
Yes,
lordship?
Mr. Babu, yeah.
My lord, I filed an application under Section 12, 1A of the Hindu Marriage Act before the family court. Case is at the stage of argument. Subsequently, I filed an amendment petition under order 6, rule 17.
At the stage of
That was
judgment.
the argument, lordship.
At
That
the
was
stage of
just
judgment.
at the stage of argument, lordship.
Judgment.
Subsequently,
Okay.
judgment not delivered
Okay.
because rejected only on the ground that my application was filed under Section 12(1)(a), but I wanted to shift that down. That is not correct. I wanted to incorporate that Section 13(1)(b). Lordship's finding is wrong, lordship, not sustainable law, because as per facts, lordship, my amendment petition, lordship, will find
Each.
page 27 start, relevant portion, page 30 to page 27, the amendment petition. And I wanted to insert that section, lordship, section page 32. Lordship will find
In
bottom
this case,
schedule.
in this case, have the parties opted for a mediation?
But
Have the parties opted for mediation?
I have no such instruction, no instruction in this regard, Lordship.
Can you get instructions over phone and tell us? We'll take it up after some time. Try to get instructions if the parties, because this is a suit
And
of the year 2018. We just wanted to
2018.
know, because of that old pendency, has any attempt has been made for a mediation between the parties?
in this regard, no instruction, Lordship.
Just take a call.
But in this
Once we
case,
decide the things go out
I,
of our hands,
and the pendentialized maintenance amount of rupees
we are not on those things. This case, we are not on
That's
maintenance.
the case,
It's
Lordship.
a case of 2018. We are just asking you if the parties at any stage have been, had negotiated a settlement through mediation. It may, there may be a mediation, it may have failed. So we are not on that, whether it has failed or not. Just wanted to know if any mediation between the two sides have been, attempt has been made. Just try to find out. Take it up after some time.
Take up any, on day after tomorrow, take up the matter. In the meantime, you will take in.
Okay.
Day after tomorrow.
Both sides are duly represented. This, the suit between the parties is of the year 2018. So accordingly, to respond to a court query as to whether any attempt has been made for mediation between the parties from the learned counsel for both sides. Take for some time to obtain instructions. Next list again on 13/5/2026.
Obliged.
Daily item 14 for hearing under order 51 rule 2 CPC.
In this matter, I have been informed that the copy I have served upon my friend, it has contained some defects, Your Lordship. I'll have to furnish a fresh copy to him. He is not prepared for that matter, Your Lordship. I could not furnish a fresh copy. There's some pagination and some pages.
Okay,
and
when?
Good number of pages missing, my lord.
It's okay. When do you take it up?
So I can serve it, but 20th onwards, I will not be there for 2 days. I have some difficulties on 20th to 23rd, Your Lordship.
3rd June, my lord.
It's okay.
When on 3rd June?
My lord.
3rd June. Yes.
Okay. Both sides are represented. Mr. A.K. Hussain, learned counsel for the respondent number 1. You say that Mr. B.J. Mukherjee, learned counsel for respondent number 1, has submitted that due to inadvertence, the copy of the memo of appeal
No, my lord, he is a appellant.
provided, this is okay, provided to the learned counsel for the respondent is incomplete, and therefore he prays for a day's time to provide him with a fresh copy, correct copy of the memo of appeal. So he submits that he would be out of station for some personal reasons, and therefore six. Please, the matter be listed after 2 weeks. Okay. The copy of the correct copy of the memo appeal be provided to A.K. Hussain, learned counsel for the petitioner within 2 days. Next paragraph. List the matter as straightforward, list the matter on P6/2026 for hearing under order 41 rule 11 CPC.
Supply item 28 for hearing under order 41 rule 2 CPC.
May it please, Your Lordship. In this case, Lordship, the plaintiff is a
Just now,
appellant.
just now. between the two sides, who is the plaintiff?
Lordship, the appellant is the plaintiff. Suit was decreed by the learned trial court and thereafter in execution, sale deed was executed. Suit was for specific performance of contract. Sale deed was executed, records were, mutation were corrected in the name of the appellant, and possession was also handed over by the help of the court, Lordship. Suit was decreed ex parte as because defendant after receiving notice did not appear, did not file
But
any written.
the appellate court passed an order
Lordship,
on the basis of paragraph 54 at page 50.
page 50, Lordship.
No, sorry, it's paragraph 54 of the judgment is at page 101.
Yes. The respondent, even after obtaining the decree, has initiated and filed title execution case number 1/2022 by misleading the learned Munsif Chirang Kajalgaon. From the record, it appears that the respondent, after obtaining decree in so and so without filing the proper petition for execution of decree under the provisions of Order 21 Rule 11(2) of CPC in proper format, had directly filed a petition under Order 21 Rule 34 read with Section 151 of CPC praying for execution of registered sale deed as per judgment and order dated so and so, not as per decree, without submitting the certified copy of the judgment and decree, which is must, and misled the honorable court to register the said petition filed in title suit 2/2020 as the court become functions officio after passing the decree as title execution case, and on being misled at the instance of the respondent, Alanan Munsif Chirang being misled, registered the said petition as title execution case number 1/2022 wide order dated 16/11/2022, but nothing was mentioned in the order that the execution case has been registered and proceeded with directing the solicitor to execute the sale deed wide order dated so and so, executed the sale deed without any information and intimation to the appellant being alleged judgment debtor. Thus it becomes clear like crystal that the procedure of law has not been followed by the court at the instance of the respondent Nira Brahmo.
The
But
second
Lordship,
finding we find at page 62, that is also one of the reasons.
Lordship, but Learned First Appellate Court held that in a specific performance of contract case, possession cannot be handed over when plaintiff did not ask for possession, Lordship. But it can be, Lordship. Manikem, your Lordship, Babulal, those says that there is no requirement to ask for possession, Lordship, in a specific performance of contract act. As soon as the court directed to register a sale deed, Lordship, it means itself that possession can be handed over.
Here's that citation.
Lordship, Manikem, that is. One is Babulal, that is 1982 Supreme Court cases, 525. Another one is Manikam, Thandapani, and another appellant.
1982.
Does it, Lordship, I have copy. In 1982, paragraph 13, Lordship, the expression in subsection 1 of section 22.
You are reading which paragraph?
13, Lordship.
Three zero.
In 1982.
30.
13. And thereafter, Lordship, this is 2000 Manikam judgment.
This, you have to dissect this judgment again. Please come to page 529.
Lordship.
Yes. Now, please read the judgment on Lara Durga Prasad quoted here. In a suit instituted by a purchaser against the vendor,
Lordship.
the subsequent purchaser for specific leave for if the plaintiff succeeds, the proper of the
First paragraph, Lordship. Page 529, first
529.
529, first paragraph.
Subparagraph, it's a quoting of quotation from Lara Durga Prasad.
Lala Durga Prasad.
Yes.
In a suit instituted by a purchaser against the vendor and a subsequent purchaser for specific performance of the contract of sale, if the plaintiff succeeds, the proper form of the decree to be passed is to direct specific performance of the contract between the vendor and the plaintiff and direct the subsequent transferee to join in the conveyance so as to pass on the title which resides in him to the plaintiff.
Yes,
So-
next line. Next
The
two lines.
petitioner, however, did not hand over possession and remove construction raised by him despite his undertaking dated so and so. The
So
decree
this is-
holders therefore applied
You
for
see,
it.
this is 25 March 1968,
Yes,
correct?
yes.
Now, this first line of paragraph 529 is respondent 6 to 9 entered into an agreement with the respondent of 5 on June 30, 1967.
July 30, 1967.
Yes, yes, 97. Correct.
1967, yes.
Now, in the, what do you call, almost in the middle of that paragraph, same paragraph.
Under the circumstances.
No, the plaintiffs therefore filed an application for injunction restraining the petitioner from making any construction. The petitioner, however, gave an undertaking on March 25, 1968 that he was making construction at his own peril and would demolish.
The construction.
Correct.
Yes,
So under these facts, this case is being decided. Now, if you please come to this paragraph you were reading, 13.
13.
Yes. 13, starting of that paragraph 13, please read that.
The expression in subsection 1 of section 22 in an appropriate case is very significant.
The plaintiff may,
Asks for the
Relief of possession.
or partition or separate possession in an appropriate case.
in an appropriate case.
Lordship.
Then, as pointed out earlier, in view of order 2, rule 2 of the CBC, some doubt
Some
was
doubt was
entertained as to
entertained.
whether relief of subject performance and partition and possession could be combined together in one suit. One view is that the cause of action for claiming relief for partition and possession could accrue the plaintiff only after he acquired title on the execution of sale in favor. You see, there are three situations. Number one, a party who is holding the land enters into an agreement.
Lordship.
There may be another case where the party makes an agreement for sale in respect of a joint property. So their issue of partition will come.
Partition will come.
There is a third, what you call, third is that the suit not based on title. That's the third one. Now, after this, you come to about 7, 8 lines from below.
Similar.
In a case where exclusive possession is with the contracting party, a decree for specific performance of contract or sale simply cited without specifically providing for delivery of possession may give complete relief to the decree holder. That means after an agreement, if you are in possession, a simply cited decree of title would help you.
Yes.
In order to satisfy the decree against him completely, is bound not only to execute the sale, but also to the party in possession of a decree of the decree holder. This is in consonance with the provision of 55(1) of the Transfer of Property Act, which provides that the seller is bound to give possession on being so required.
Yes. So in the instant case, Lordship, there is an agreement. The appellant paid some loan to the respondent, and in that agreement itself, she has already admitted that if I could not repay the loan amount, I will send my land, Lordship. So on the basis of that agreement,
I'll sell my land.
yes, Lordship.
I'll give possession is not there. In no
Lordship,
agreement it will be.
This judgment says selling means giving the possession.
No.
After relying this
It's just two
judgment,
things. Number one, that's why we have read this. It's in consonance with the provision of section 55(1) of the Transfer of Property, which provides that seller is bound to give on being so required. Now,
yes,
please come
in
to
this case,
55.
it is required to give the possession to the plaintiff. If a decree for simpliciter is,
There's no agreement to give possession.
it says that sale means you have to give the possession. On the basis of these two judgments, our High Court already allowed CRP 18414.
In your case, there's no agreement. Come to this provision, 55(1) of the Transfer of Property Act.
Rights and liabilities of buyer and seller.
Come to F directly. To give on being so required, the buyer or such person he directs possession of the property as its nature admits.
To give on being so required. So in this case, we require the possession.
But you're not there. You see, you are bound by the prayer. That's why I'm reading that those earlier paragraphs.
But Lordship, on the basis of these two judgments, one CRP 184/2014 was decreed, where relief of possession was not sought
That's
for.
okay. That is an interpretation given by the court, but we are now looking at the judgment on the basis of which the other order was passed. It may be subsidiary to it, may be particularly, we don't know.
Lordship, 2022 judgment also says in the same footing that after discussing Babulal and other judgments, this Manikam judgment says, paragraph 29, last page, page 11, to examine whether a provision is directory or not.
Last time also, I come to paragraph 2 of this judgment, Manika.
The brief facts leading to the present appeal are that the respondent defendant as owner of the vacant plot at measuring so-and-so had entered into a sale agreement with the appellant. One of the conditions in the agreement was that the respondent would hand over vacant possession of the suit property to the appellant. The relevant clause
This
is
is a
that
condition.
there was an agreement.
This is a condition. And therefore, you have to show that in your agreement for loan, you had an agreement for handover of possession. In both the cases, you see, that's why it says it's required. If there is no agreement to hand over possession, you may have title without possession. In this judgment, you will also find that this here somewhere it says what do you call it? It's a handmaid of justice. Procedural part is a handmaid of justice. So what will be the procedure? If you have an agreement for possession, then you get possession. But if you don't have an agreement for possession, can you be granted possession? That will be relief, not asked for.
But in these cases, it says that even in specific performance of contract act, even if the plaintiff did not pray for relief of possession, after executing the sale deed, it is required to put the plaintiff in possession. So accordingly, learned trial court examined the matter and decreed the suit in favor of the plaintiff.
The same thing, you see, come to paragraph 7.
of the judgment.
Same thing.
Money came.
Money.
The appellants deposited the balance sale consideration, but the respondent did not come forward to execute the sale deed. Therefore, the representative of the learned executing court, that is learned principal sub-judge Pondicherry, executed the sale deed so and so. The sale deed had the following assertions. Now by this
You
deed
first
of
forget this one. No, read it, you will
the
be then
purchasers.
complete. You know, read now by this date. Read that.
Now by this deed of sale, the property fully described in the schedule hereunder is hereby transferred, conveyed and assigned to the purchasers with all privileges, easements and advantages whatsoever to the said property to the occupied and enjoyed with absolute right, title and interest without any claim of demand whatsoever to anyone, free from all encumbrances. The purchaser shall hereafter peacefully and quietly possess and enjoy the property described hereunder without any interruption or disturbances whatsoever from the vendors or any person claiming through her.
So that is the sale deed. Sale deed says that with this agreement and with this deed, right is transferred and assigned to you.
Yes.
Second clause says that you will be entitled to enter into possession, and therefore court says that it's an inherent part because this is a sale deed executed by the court.
Yes.
Therefore, the procedural part is a handmaid of justice.
Yes.
That's the precondition. That if you have an agreement, you get possession. But if there is no decree for possession, can you be given a decree, execute a decree for possession? Both Manikam and this are distinguished on that point of view.
There is a decree in favor of the petitioner, page 17.
No,
order.
there's no dispute with that.
Yes.
The question is whether this possession was decreed. There being no prayer.
From the pleadings also, Lordship, if reading from the pleadings, it is discernible that the plaintiff is seeking possession, then the court can mold the relief also.
You see, that was not done. Court has a power to mold reliefs.
I mean,
But you have to show that this the issue of possession were decided by the trial court. We are missing that point. You see, I personally read it.
Lordship.
I don't read it intently. I don't read one word by word. I may have missed it.
3 points were discussed. Defendant entered into an agreement or not with the plaintiff, whether the plaintiff gave rupees 6 lakhs as loan to the defendant, whether the plaintiff is entitled for the decree.
No, I'm not on that. What I'm asking is, in the discussion in these 3 issues, was the issue of possession ever decided by the trial court? Entitlement to a possession. If that is there, then we admit it and we issue notice.
But in fact, as per that agreement, they have already obtained permission from the authority.
Everything is okay.
Yes, and they admitted that she has, one of the witness was also examined.
Here is a decree. We'll take it up next week. You'll be prepared on that point.
Lordship.
He'll not be there. He'll not be there next week.
From 20th, I will not be there. Before that,
From
any
20.
day.
Then we take it up on Friday. Oh, sorry. 15th is Friday. Take it on 15th then.
Next Monday. Yeah. Next Monday, Lordship.
Okay. Next Monday is 18.
18, Lordship.
Okay.
I'll place that judgment also, Lordship, where it is said that when there was no prayer for possession, in that case.
No, you can place it, but you see, we have these 2 you referred.
Lordship.
These 2 are the authorities on the basis of which it was interpreted in the third case.
Lordship.
So you'll have to see what these 2 judgments mean.
Lordship.
And that is why, since I was a bit acquainted with these 2 judgments, I have referred to those paragraphs. Where it says there's a distinguishing factor for giving that possession. In the first case, there was an undertaking.
Lordship.
And in the second case, there is the sale deed which permits entering into possession. And therefore, execution of the decree on the basis of sale deed executed by a court would be a necessarily, what you call sequel.
Lordship.
That's
There are
fine.
some other judgments also discussed in
Be
these two
prepared, yeah.
judgments. I will point out on next day.
Be prepared. Both sides are represented on the clear made by, this is R. Chaudhary, Senior Counsel for the appellant. List the matter on 18/5/2020.
Only the cases they have already started execution. Lordship. 144.
It's your choice. We can take it up to a day after tomorrow also.
Day after tomorrow. Day after tomorrow.
Okay. 13. Okay.
Obliged.
Item 15 for orders.
May it please your lordship. In this case, lordship, service is complete and PCR is also received. Office not dated 7/5.
It's a 2017 matter. We can hear it.
Yes.
9 years.
I am for a principal respondent plainly.
Then, if possible, lordship, that may be fixed for you.
8 upon Thursday then.
Thursday. Thursday.
Both sides are represented. Case is ready at Jiga's service. So as the matter is old pending matter filed on 9/2/2017. This is the matter for hearing on 14/5/2026.
Then 19, lordship. 19.
Next week.
19.
19.
19/5.
Deeply obliged.
Item 16.
Here I am looking for an accommodation matter. Here I am looking for an accommodation matter in order to find the objection against the IA matter.
What is the IA for?
I is for the stay of the order, your lordship, as it has already been admitted by your lordship. That the stay on operation is.
Has to follow. Execution can't proceed. It's a declaration of right title and interest.
Yes, sir.
You do it within this week, we'll take it up next.
2 weeks,
No.
Parking.
No.
Next Thursday.
So then if you see, we'll give you time only, 10 days time only if you undertake that it will not be executed. You can take instructions from the party and then tell us. Otherwise, there will be difficulty on you.
Next week I'll be filing.
Next week, okay. Both sides are represented. Mr. Dekal and counsel for the
Respondent 1 and 2.
number 1 and 2. Place for in granted 7 days time. File the objection to the interlocutory application. Based on 22/5/2026.
Carry on.
Carry on. 4 and 5. Just a thought. You have to the comment. Mr. I'm sorry, forgot the name, Mr. I forgot the name. That's right.
Yes, that's fine.
His last then council and then government advocate appeals for respondent number 3 and 4.
4 and 5.
4 and 5. And you appear for 1, 2, and 3.
1, 2.
Who is for 3?
He is, no one is.
See the appeal abated.
Hmm?
Appeal is abated against the team.
It is abated against 3.
Yes, substitution application was dismissed on the last occasion.
The legal heirs were not allowed to be included
Why?
because of the delay in substituting.
Okay, just say that, the appeal is abated against the respondent number 3. But if it is abated and the decree is, what do you
Degree,
call
I
it?
was the plaintiff, Your Lordship.
Huh?
I was the plaintiff,
So your suit was dismissed,
yes.
but the interest of the,
They are we are claiming a Khatian
no,
under
the-
that.
just that's why I'm asking. Page
Joint
46,
decree.
page 46 is your prayer
Yes,
on in the suit.
yes.
In the suit, the prayer is for decree of plaintiff's possession of the suit land and for confirmation of possession.
Yes,
Now, if it abates against one of the owners, that is respondent 3,
I
then
understand,
how
Your
do you
Lordship.
stand? Where do you stand?
Because they are the brothers, all three of them.
We understand, but there is an
I
ultimate
understand.
interest. What happens if the appeal abates against 3? Where do you stand?
In the entire.
I have to check, Your Lordship, because let it come up.
No, it's okay, I'm just trying to understand, that's all.
Yes, understand. Whether it is separatable, I have to check.
That's right, that's right.
Then understand, Your Lordship point.
Stated the bar that the appeal is abated against respondent 3. List on 25th.
Fifth, Your Lordship.
Yes, bro.
25th, you want. Thank you.
Obliged.
Item 17.
Wait, please, Your Lordship. Well, although the office note in this matter says that respondent number 2, with regard to respondent number 2, AD card has returned answer. My lord, I see on the website that they have filed the wakalatnama this morning, my lord. On the website of this honorable court, they have filed the wakalat, respondent number 2. The trial court records were called for in this matter. They have not come in as yet, my lord. By order dated 19/7/24.
Okay, you are appealing for?
I for respondent number 1, I have entered appeals, I think there is some mistake.
No,
Today I
there's,
filed wakalatnama. I filed today for respondent number 1.
and someone filed on 7/9/24 again.
For respondent number.
Both the names it gives, my lord, the website says that respondent number 1 and 2, both. So and so.
Print out. Print out of the status of this CRP IO 224 or 24.
Lord, office note dated 3/10/2024, my lord, that shows that the service on respondent number 2 returned because the address was not properly given. And thereafter, whether a re-steps was taken, not known.
It was
Then-
taken on.
Then
30th.
5/5/2026, my lord, last,
Okay, that you just.
yes, if they have appeared, my lord, then matter ends there, my lord. The suit of 2008, my lord, this stay order is operating from last 2 years, some urgency is there, my lord. And LCR was called for, my lord, specifically.
Yes.
Not come.
The records are also not here. Which page is the order under challenge?
My lord, pages 97 to 99, begins at page 94, annexure 8. Lordship.
Yes, there are two Wakalatama. One is Mr. Bharali, your name is shown. The other is by Mrs. P. Hazarika.
Yes, madam. My junior, my lord. I have signed also, my lord. Yes, and me, myself, my
But
lord.
why two Wakalatama? By respondent number one.
Earlier he appeared, now today also I am in support of him, my lord. I have entered, my lord.
I'll take fresh steps in that case.
Then you both have let me down. Few moments back, I said that day one, two friends, old friends, what you call, in my earlier profession were there. Day one also, they could handle, and now you have to support him. Mr. Bharali? Few minutes
When
back,
the
I was
foundation
telling
is
both of
weak,
you.
my lord, more reinforcement is required, my lord.
Interesting admission, my lord.
Okay, then against you, which is not complete.
The address was, my lord, whether address was properly given.
That is the address in the suit.
My lord, one aspect of the matter, my lord, from 2008 suit is going on, and respondent number 2, my
see-
lord,
you
he
see-
never appeared, and it was
No,
ex parte.
it's not that. Respondent number 2 is your son.
Mine?
Is your son.
No.
Yes.
Respondent number 2 is the sister of the
Sister
seller,
of the,
my lord, the defendant, my lord. And she never contested, my lord. And it was ex parte.
husband, late estranged husband of the
So
petitioner.
her appearance in this case is also not, I mean, my submission is may not be required, my lord, because she never contested. It was ex parte against her, my lord. And suit is on the verge of completion, my lord, almost.
Maybe, but
In that view of the matter, only for respondent number 2 being delayed, like, whereas
but you
she
see-
never contested the suit, my lord.
Procedure, that's fine.
that
And
is the
it
reason
proceeded-
the records would be necessary.
But then please tell us, come to page 15 of your brief.
Of my application, my lord.
Yes.
Lord,
The defendant number 1 is the petitioner.
Yes, my lord.
Defendant number 4 is the respondent number 2.
yes, ma'am.
Yes, my lord.
Correct.
Yes. my lord.
Now, why you have not implemented this 2 and 3 again?
My lord, they are the sons, my lord, of,
Defective. The petition
Ought
would
to
be
have been, my
defective.
lord. If they are parties to the suit, my lord, they are acquitted, my lord.
If they
I'll
are
file
parties
an
to the
application,
suit,
my lord, to implement them.
if they are parties to the suit, just join on it goes.
I think they have filed something to the effect that they are not.
And the trial court has rejected the prayer of your petition
Yes, my lord.
to produce income tax returns.
My lord.
Beg your lordship's pardon.
Return, whose income tax return you were seeking?
The plaintiffs, my lord.
He is the plaintiff.
Yes.
He is the plaintiff.
Oh, you will not be getting that. You will not be getting that. You see, his answer is very simple. For some reason, you file a suit against India's top 10 industrialists and say they agreed to give me a loan of rupees 100. File a suit. And then in the suit, you make a prayer, all these 10 industrialists will give me produce their income tax record.
No, my lord, they filed a suit that,
It's okay, but
yes, ma'am.
what does the income tax record mean? Let us say that you wanted to prove something, that he does not have an asset of rupees 100,
Yes, my lord.
correct?
Yes. And that was not the issue, my
Does
lord,
it,
at any
does it
stage.
mean that if I, without rupees 100, cannot enter into a contract for
My lord.
purchasing a property
Exactly.
at rupees 100? I may take loan from 10 people
Yes.
and get 10 rupees each and get 100 rupees and then
Yes, my
buy
lord,
the
but
property?
that in my humble submission must be reflected in my accounts. That in my.
No, not required. Not required. You see, I'll give you a very simple example. I've given you this same example. I am repeating it in a different way. Now you go and purchase, you have booked a flat
Yes, ma'am.
for say 100 rupees. And you have in your pocket 10 rupees.
Yes, please.
Is there a bar that you cannot make an agreement for sale for a flat at 10 rupees
Agreement for,
for sale?
of my
Purchase that
flat,
property.
of
You
the
want to
flat that
purchase
I'll
a flat. Yes. You want to give Mr. Chakravarti is a builder. You want to purchase a flat from him.
Yes,
Is it required that you will have 100 rupees in your pocket to make an agreement for sale with him?
Exactly, madam.
Not required.
not.
Number two, he agrees that he will give you that flat. Takes 10 rupees from you for 90 rupees. Can't you go to a bank and say that, look, I don't have that money, but please give me loan of 90 rupees. I want to purchase my flat. Is
Yes,
it
but
required
but-
that before the agreement,
Then to bring my wife, who is in no way connected with me,
we don't know about those things?
that is the suit what
But
it is about.
your case is about only income tax return.
Yes,
Yeah.
madam.
Income tax return is something personal to him. You will not get it. Not even by the orders of the court.
Well, in the written statement, no such stand was taken,
It
madam.
was
I think
taken, my lord.
absolutely.
That is incorrect.
It's okay. Maybe correct or incorrect.
I'll Lordship may grant me time to take steps on respondent number.
Not required. It's not even maintainable. Why it is required for taking steps? How do you prove an income tax record?
Well, the transaction was entirely in cash.
So what?
Lordship grants me time, my lord, I'll satisfy this honorable court.
Take it up day after tomorrow.
Lordship,
You see, he may agree to a prosecution under PMLA. He may stand prosecution for disproportionate money which he has money for paying cash. But does it preclude him to make an agreement? No. He's one of the worst men on earth. He takes bribes. He does not have any white money.
but the suit is for declaration that I am bound by that agreement, the wife of an estranged husband.
Right. So that the income tax return wouldn't say anything.
Lordship grants me time, I'll satisfy this honorable court.
What says it presented? Though the notice on respondent two is not yet served and the records of the child court as called for is not received. But the issue involves as to whether the petitioner would be entitled to call for the income tax records of the respondent number one. Accordingly, the court proposes to hear the to hear both sides on the said point. List on 13.
Can it be subject to the convenience of this honorable court, 20th of this month? Yes, my lord.
205. Okay.
Deeply obliged.
Hearing day, madam. Hearing day.
Yes,
It's not a hearing day. 25 is a motion day, Wednesday. Okay.
obliged.
Item 18.
As per order dated 4/2/26,
Just a moment, both sides. Mr. Just a moment, just clarify. It appears that two Wakalatnama has been filed for the respondent number one. Therefore, service on reform is incomplete. No, we just added, there are two Wakalatnama for respondent number one.
Yes.
That we forgot to add. We
Right.
just added that in the order.
Complex.
my lord, probably this matter has come for regarding service upon number 2. As per order of this honorable court, we have taken steps to cover publication, my lord. There was an order of 4/2/26. Accordingly, we have published and filed an affidavit, my lord. And I
Where is
think it
that?
is on flag B, I think it is. Okay.
Lordship, I am appearing for what?
But we live in a strange world.
Well,
We live in a very strange world. You are relying on page, annexure 1, page 94. It's not the original newspaper. You have just given a photocopy of a advertisement.
yes, no, so we have things the original is with us, my
You
lord.
have to find it.
We can,
You have to keep it on record, the original, because we live in a strange world. Take it on record.
Like.
Order one or take other land for respondent for the petitioner submits that an affidavit of newspaper publication of summons has been filed on a basis of the said affidavit of sorry, additional affidavit of service for my seeing that the original newspaper is not filed, so according to the learning council for the petitioner shall file the original newspaper by way of an additional affidavit in course of this week, at least on 18/5/26. Within this week you file it, so it will come 18, next Monday we are fixing it.
18/5, Lordship.
It is the 20th minute, because after that, that 20 minutes.
20.
Well, there is an interim order of I think.
What is the interim order?
Stay of the proceedings.
Actually, argument was deferred.
Argument is deferred.
The case was in argument stage actually, before a learned trial court.
Where is the cross-examination of DW1?
Yes.
DW1 minute, it is page number 63 minute.
63 onwards, yes.
53.
The 63 minute, the original vernacular is there. The two ground was that minute in
Where is the petition for re-examination?
76 minute.
You are the defendant number one.
Yes, sir.
The order is perfectly correct. What is wrong in the order?
My lord, there is no pleading, my lord. Neither the plaintiff nor the
See,
defendant.
that's not the point.
Yes.
It's a cross-examination.
Yes.
He put certain questions to you in cross-examination.
Yes.
You, in your defense, you take a ground that the entire house was demolished.
Yeah.
In your cross-examination, when he asks questions, you say that there was a fire which gutted the remaining house.
Yes.
Correct?
Yes, sir.
And for that ambiguity, you want the additional re-examination.
Yes, sir. Really.
That's not your case. In your re-examination, you can't give evidence beyond pleadings.
Re-examination was a statutory right, my lord, for my lord.
It's not a statutory right, it's a procedural right.
Yes, my lord.
But you have to satisfy the court that you have a ground for re-examination. You just can't bring witnesses for examination, re-examination again and again. You gave evidence, you were cross-examined on 5 days.
So regarding my lord, re-examination is regarding only explanation for a particular, my lord.
You see, explanation of what? You will explain only your pleadings. Can you give evidence beyond pleadings?
There is
You
for
see-
explanation is required for that, my lord. There is not a
Adil,
pleaded ground.
nobody asked you to give an evidence that your house was burned by fire.
Yes.
You volunteered an answer. The house was gutted by fire.
Yes, Lord.
And then you come to court and say that I want to give additional evidence or to re-examine myself to clear that ambiguity. Who brought in this issue of fire? You gave that statement.
Yes, ma'am. Only for an explanation, my lord, the what provides section 137 and 138, my lord.
Basic principle. Is it permissible for you to lead evidence even in re-examination of a fact which is not pleaded?
Yes, well, that is my case, my lord, that it is not a pleaded case of the plaintiff or the
He
defendant.
can ask you anything.
What is my
In the
lord?
cross-examining, he asks you whether you are the president of India. Is there any law which says that in cross-examination you cannot ask anything which is beyond pleadings? That's not the law.
Yes, my lord, it is correct, my lord. It is correct.
He
It
asks
can be
you-
asked beyond.
He asks you whether you are the president of India.
Yes.
And now you think it's an opportune moment. I'll take the ground in this and then claim my right as a president of India. And you say, now I want to explain this question. I want to say that, yes, I am a legally nominated president of India. You want to give that evidence in a suit for specific performance of contract. Is that permissible? Answer is no.
Actually, suit was for damages, actually.
Whatever, we are just giving an example.
Yes.
You never asked that question whether you are president of India. It's just an example.
Better may come on next week, my lord.
Nothing,
I'll
nothing
satisfy.
come.
Yes.
Actually, Lordship is pending since the days of 2012. Argument is being deferred because of the pendency of the CRP. before
Otherwise, my
argument.
lord, the two other witnesses there, my lord, their cross-examination is not, my lord, taken out. Before, my lord, taking their cross-examination 2 and 3 is there. Two witnesses also there, my lord. So before taking their evidence, my lord, it is.
You shows that you want to lead evidence which is within pleadings. That's not there.
Not there.
Yes, sir. Not there, my lord. The what is, my lord, kept in the cross-examination, that is not the pleaded case of either of the parties, my lord.
Should you refuse to answer?
Yes, sir.
Who told you to give that answer? You said that our question is beyond pleading, I will not answer.
Yes.
You volunteered an answer. And then you can't say, I will explain that further.
But, my lord, she is a lady of about 86 years old, aged, my lord, lady. And I
It
think.
shows the authority which says, permits you to give an answer and then explain it. Which is beyond pleading. Show me one authority which says yes.
Better come on Monday or Tuesday, Wednesday.
No. So that's the only point. We are unnecessarily dragging this matter.
Yes, Lord.
for long
My
time.
lord, there are 2 points, my lord, in this revision petition. One is, my lord, this re-examination. Another is, my lord, our 2 witnesses is not given the chance of cross-examination. They are not cross-examined, my lord.
Who?
Defendant number 2, DW 2 and 3, my lord.
That's not the issue before us.
Yes, my lord, two, my lord, for 2 grounds, my lord, this revision petition is filed, my lord. Prayer is, my lord, there, my lord. Because the case is fixed for argument without cross-examination of the DW 2 and 3, my lord. In my prayer is,
order?
yes, the order, my lord, is the last page. Page number, my lord, 80, last part, my lord.
Page
Page 80, my lord,
80.
80. And this is page number 83, it is held that whether there is pleading regarding setting of fire. Page number 83.
There's something we are missing. Please come to this order at page 75.
Page 74.
Page 75 is the report. Correct. Course of DW1
Yes, my lord.
completed
Yes, sir.
on 10/8/2023.
Yes, Lord, sir.
After 10/8/2023, your petition for re-examination on 16/8/2023, page 76.
Yes, sir.
This order is on 22/10/2024. What happened in between? Why you did not present your witness for cross-examination?
My lord, the next day we filed the application, my lord. And the application was pending, my lord, in that period.
Pending.
Yes, sir.
2 and 3 has to be allowed.
Yes, Lord, but they did not pursue the matter. They did not brought the witnesses before the learned commissioner.
Because that.
Otherwise, you would have cross-examined them. At the appropriate time, they did not brought the witnesses.
But look at this order, this what do you call note of that, what do you call the commissioner?
Commissioner, yes.
I just showed you that page. It's page.
Other DWs, my lord, can be from the cross examination, page number 75, my lord, for extension of time, my lord.
Page 75
Yes.
is that order. Sorry, Commissioner's note. Commissioner says that DW1 were discharged, that remaining DWs are yet to be cross-examined. Cross of DW1 recorded on so-and-so is also submitted. I therefore submit an original copy of so-and-so before this court and also pray for extension of time so that other DWs can be cross-examined. So Commissioner is seeking time, but could not have
Yes.
closed it.
Yes, yes.
Permit him to bring that witnesses
Yes.
2 and 3.
Let the witnesses, other witnesses may come, but so far the re-examination of DW1 is concerned, it cannot be allowed at any cost.
Not permitted.
Because case has been cracked upon your honor
That cannot permit.
in view of the cross-examination of DW1. So far the damage claim is concerned in the original suit.
You give us that copy of the newspaper.
Like
The court master will keep it on record.
it.
Heard Mr. M.J. Kadir, learned counsel for the petitioner. Also heard Mr. H. Sharma, learned counsel for the respondent, number 1. Next. None appears on call for respondent to by substituted service of notice to newspaper publication dated 13/3/2026 and 15/3/2026 is brought on record by an additional affidavit filed on 25/3/2026. As the original newspaper were not next, the learned counsel for the petitioner has produced the original newspapers. The same is accepted and made a part of record. Next paragraph. By filing this revision and this application under Article 227 of the Constitution of India, the petitioner, who is the defendant number 1, has defendant 1 in TS 216 of 2012 As I said, the order dated 22/10/2024, passed by the learned civil judge within bracket senior division, bracket close Kamrup Metro, Gauhati, in the said suit, by which petition number 4008/2024, filed by the petitioner dash defendant number 1 for re-examination of the petitioner within bracket DW1, bracket close. Next one. The next part. The challenge is also made on the ground that by the said impugn order, the learned trial court did not allow the petitioner to produce DW2 and DW3 for their cross-examination, and that the matter was fixed for argument without closing the evidence of DW2 and DW3. Next paragraph. With regard to the second prayer made in this application, which relates to non-providing of opportunity to the petitioner to present DW2 and DW3, we take note of the contents of this application, where at page 75, it is seen that the advocate commissioner, who was hitherto recording the cross-examination of DW1, has given a report to the learned trial court in connection with TS 216 of 2012, prayer for extension of time, amongst others, stating that the DW1 was cross-examined and discharged on 10/8/2023, and that the remaining DWs are yet to be cross-examined, and therefore the advocate commissioner had made a prayer for extension of time so that other DWs can be cross-examined and cross-examined. Next paragraph. It appears that upon completion of the cross-examination of DW1 on 10/8/2023, the petitioner dash defendant number 1 filed a petition on 16/8/2023 under section 138 of the Evidence Act, 1872, read with section 151 of the CPC for re-examination of the DW1. First off, in the said petition, it is projected that during cross-examination, the petitioner as DW1 had made a statement on 8/2/2023 regarding setting on fire the tenanted premises of the plaintiff by defendant number 2. Full stop. accordingly, it is projected by the petitioner that that some explanation is required about setting on fire of the tenanted premises of the plaintiff, which arose from the cross-examination of the defendant from the petitioner as DW1, which was not the pleaded case of the parties. Next para. The learned counsel for the petitioner has submitted that as the destruction of the house of the respondent plaintiff, respondent number one plaintiff, by fire was not the pleaded case of either side, comma, some clarification is required. Next para. Having heard the learned counsel for the respondent has opposed the prayer made in this application. Next para. Insofar as the prayer for examination of DW of the petitioner dash DW1 is concerned, comma, it is in course of the cross-examination that the petitioner as DW1 offered an answer stating that the house, that the tenanted premises were set on fire by defendant number 2. Full stop. Therefore, with the answer that is volunteered by the plaintiff dash defendant DW1, comma, the learned trial court is found to have committed no error for refusing to re-examine the DW1 as the point which is sought to be clarified by re-examination regarding fire on the tenanted premises by defendant number 2 was not the pleaded case of the petitioner in the written statement. Therefore, comma, the said part of the order does not require any interference. Next paragraph. Insofar as the second prayer regarding the non-providing of opportunity to the petitioner to bring DW2 and DW3 for cross-examination, comma, it is observed that there is nothing on record to show that the evidence of DW2 and DW3 was closed. However, the materials available on record of this in this application shows that on 16/8/2023, the advocate commissioner has prayed for extension of time to complete the cross-examination of other DWs. Full stop. Yes. Therefore, comma, as the learned trial court did not close the opportunity of cross-examination of DW2 and 3, comma, the impugned order dated 22/10/2024, by which cross-examination of DW2 and DW3 was not provided and the case was fixed for argument, is not sustainable on facts and in law. And the same is vitiated by perversity, as the learned trial court did not take into consideration the fact that evidence of DW2 and DW3 was not closed. Next paragraph. According to comma, insofar as the second part of the order is concerned, by which the case was fixed for argument, is hereby interfered with. Next, the learned civil judge within bracket senior division, post number 3, Kamrup Metro, Gauhati, shall fix a date for cross-examination of the DW2 and DW3 before the, to be conducted before the Advocate Commissioner. First off, please clarify that no interference is called for with regard to the refusal for re-examination of the petitioner as DW1. Next, what is this? Interrogative, this application stands partly allowed, the extent as indicated above. Next paragraph. It may be recorded that this court had banned by orders passed earlier had requisitioned the records of what is stand up to the records received. What is the date of the interim order? First paragraph.
22/10/2024.
2024.
22/10.
So something the extent of the record, it appears that you will miss that opportunity also. You've not seen the records, but this is the order sheet. You were given last chance to produce your other witnesses.
Yes, sir.
By order dated 24/7/2023. This you have not got on record.
Hello.
If that was in last opportunity, I encourage the default. This order you have suppressed.
This 24/7/23 for DW1, my lord.
Last chance to produce.
This is for DW1, my lord. 24/7. DW1 was time taken for her illness.
Yes, correct. You see,
DW one, my lord, but here is DW two and three, my lord. Two and three not a fixed, my lord.
what's doing that? After the, after the. Then it 23, right? Yes, you're right. Then it 23. The commissioner's report is on 10/8/2023.
Yes,
Correct.
my lord, and on
Ah,
16/8 we have,
Then it's right, then it's right.
on 16/8 we have
order.
filed, my lord, for
No, then it's right,
re-examination, my lord.
then it's right. You see, look at the order. You read the order loudly, then you'll understand what is wrong about your submission. Read the order loud.
24/7, my lord, parties are represented in the report submitted by learned advocate commissioner stating that further cross-examination of DW one could not be completed within the given period due to the ill health of DW one,
Please read.
and that both parties requested to take extension today. In petition number so and so filed by learned counsel for the defendant seeking 3 weeks time for appearance of DW one for facing further cross-examination as well as for cross-examination of other DWs.
Yes.
Yes, heard in views of the, in view of the commissioner's report, petition is allowed as at last chance considering the old pending nature of the suit.
So in your petition, there was two pair. Number one, extension of time for cross-examination of DW one
Yes, ma'am.
and for other DWs.
Yes.
You were given last chance.
Last chance.
Next date is for report on 10/8. For report
16/8, my lord.
16/8. After
16/8.
that, you see 16/8 is presenting takes up.
Yes,
You
ma'am.
don't file and pay for extension of time for other DWs.
The 16/8, my lord, we have filed for re-examination, my lord. So without
Please answer the query which you have to.
yes,
In that, it's not your case that on 16/8 you filed another petition to extension of time for DW two and three.
yes, ma'am.
You did not file, so you waived your right. You were given last chance, that is gone. Once it is gone, we don't interfere with that order.
No, my lord, since the DW one was not complete, my lord, DW one, our
This order, you did not show it to us. In this repetition, this CRP, this order is not there.
yes, but on 16/8, my lord,
Why? You were given last chance. Why do you withhold that order from us? It is for us to consider what you want to mean. Why would you not produce that order? We want to encourage non-production of entire material.
So, my lord, since my lord, re-examination was not complete, my lord, of the DW one, my lord.
So you presume that others will not be required, despite last chance by the court.
That may be, my lord, and on due to pendency of this, my lord,
Petition.
my lord, due to pendency of our application, my lord.
You see, you have spent some time in that court also.
Yes, ma'am.
If you have to make a prayer for extension of time, you have to make it.
Otherwise,
There's no
my lord,
presumption in trial court that once you file petition A, your prayer for prayer made earlier would stand extended.
my lord, otherwise there is no order of closure of the
We'll
cross-examination.
now provide that order.
DW,
That gap will fill up.
DW two and three, my lord.
We'll fill up that gap.
My
We'll
lord,
justify that order.
by any condition, my lord, by filing, paying any, my lord,
No.
cost, my lord, that may be
Definitely
provided,
not.
my lord.
Had you produced this order and then you have sought for the leave of the court, we would have understood. But this is something which suddenly struck me, even despite passing of the order, we just reconfirmed from the trial court record.
Yes, my lord.
Had you told us, we would have not gone through it. Once we spend time looking at the record and something adverse comes against you, we will not
My lord,
be complacent. We
my lord,
can't
that
permit
may be a bona fide, my lord.
It would encourage, what you call, a practice of hiding things from court. Suppression of material facts, you
My
take it very, very seriously.
My lord, in fact, my lord, it is only a bona fide, my lord, presumption that the due to pendency of the
It is
petition of
available.
re-examination.
There is a presumption available that if I file a petition, things will be adjourned. There is a presumption. I don't think so. At least I did not have knowledge of that.
And since there is no order of closure, my lord, so we have
We
thought, my
covered
lord.
that gap. But this is, if you, had you produced this and you have asked for the liberty, you would have acted differently. But this is a case where you have suppressed material facts.
In fact,
That
my
you were
lord,
given a last chance was not brought to a notice. We did not permit that.
my lord, that may be a bona fide mistake on the part of the my
Not
lord
bona fide mistake. It
counsel
never happens.
regarding.
It never happens. Because you see, where you are standing, I was there once. I know that it never happened.
My lord, for the end for that, my lord, any amount of cost may be given, my lord, for that. Otherwise, my lord, in some cases, my
Mr.
lord,
Kadir, I have a very simple answer.
yes.
I am repeating it for last 1 year. You see, I went to a doctor. He made my health checkup and then told me, sir, you have everything is okay, but your heart is not there. He did not find my heart. I am a heartless fellow. Had you produced it, we would have considered. But once you don't proceed, produce that. The amount of suppression of material facts, we want to encourage that. You had the records here. You could have gone through it and then you could have told us that this was missed. But you did not look at the record. We had to look into the records.
Yes. In fact,
And to find out this, we had to peruse, we had to spend some time looking at the records. We won't encourage that, Mr. Kadir.
otherwise, my lord, there was no
Second-
order of there, my lord, for
Second,
closure.
with regard to second pair, we, on a perusal of the materials available on the, in the scanned copy of the LCR, it is seen that by an order dated 24/7/2023, while allowing petition number, the petitioner had filed a petition number 3554 of the 23, seeking 3 weeks time for appearance of DW1 for facing further cross-examination, as well as for cross-examination of other DWs. Full stop. The last cross-examination of DW1 was recorded on 10/8/2023. And thereafter, on 16/8/2023, the commissioner submitted a report to the learned trial court, seeking extension of time for cross-examination of further DWs. Next one. In this application, the petitioner has suppressed the filing of petition number 3554 of 2023 and also suppressed the order dated 24/7/2023, by which the court had granted last chance on the petition number 3554 of 2023 for appearance of DW1 for facing further cross-examination, as well as for cross-examination of other DWs. Under those facts, when the last chance was already granted, we do not find any irregularity of the learned trial court in giving closure of the DWs and to proceed with the further argument of the case. Next, the learned counsel for the petitioner has submitted that the court did not pass any order to close the cross-examination. In the considered opinion of the court, as the suit was of the year 2012, where the DW1 was facing cross-examination, and the court had, the learned trial court had granted last opportunity for further cross-examination of other DWs, which means that the prayer made in petition number 3554 of 2023 was allowed. It cannot be presumed that merely because an application is filed on 16/8/2023 for re-examination of DW1, if there was any extension of time by the learned trial court for further examination of DWs. Next paragraph. It would have been a different issue if the petitioner would have produced the said petition number P554 of 2023 and brought to the notice of the court the order dated 24/7/2023. Of that having not been done, the court has taken a view of a suppression of material facts which disentitles the petitioner to any relief. Accordingly, this order dated 24/7/2023, having attained penalty, by which earlier last chance was granted the petitioner for facing cross-examination of DW1 and further cross-examination of the DWs, it's deemed that without a prayer for extension of time for DW2 and cross-examination of DW2 and 3, said prayer you said is deemed to have waived by the petitioner, and therefore the impugn order dated 22/10/2024, fixing the date of this for argument is not liable to be interfered with. Application stands dismissed. Next paragraph. As both parties are represented by their learned counsel, because both sides are directed to appear before the learned civil judge, senior division number 3, the senior division, practice number 3, Gauhati, on 1/6/2026, and by producing a certified copy of the order, await for further directions that may be passed by the said court. Appearance date is 1/6/2026.
1/6/2026. Obliged, Lord.
Yes, item 19.
Lordship, as per office note dated 7/5/2026, the service report in respect of respondent number 231 and 32 is still awaited. Lordship.
The learned counsel for the petitioner and the respondent number.
I am appearing for respondent number 1, Lordship.
State.
No, Lordship, she was the plaintiff, Lordship.
Okay. So, but Mr.
As A Singh, Lordship.
Assisting learned counsel for the appellants. Also, Mr. P. Nayak, learned senior counsel, assisted by.
Lordship, I'm appearing. Lordship.
Sir, sir, learned counsel for the respondent number 1. Next paragraph. As per office note dated. In view of office note dated 24/3/2026 and 7/5/2026. As notice was issued by speed post to the respondent 2 on 24/3/2026. Let the matter be placed before the Laosima court, passing appropriate orders as regards service. And the matter be listed before the court. Next paragraph. If this order be brought to the notice of the AOJ Civil Appeal Section, Second Appeal Section, for placing the matter before the Laosima court.
Lordship, if possible, if Lordship comes to the decree, Lordship, at page 116, Lordship. It was 116, Lordship. I mean the order. Lordship, it was only against the 1A, 1B, and 1C, that is the appellants, Lordship. And service is not complete in respect of respondent number 3.1 and 3.A, 3B. That one line only, Lordship.
Just before that, before this, you say, the Government Council for Respondent number 1 has referred to the operative part of the decree, page 116 of the memo appeal, and submits that the decree is only against the
Appellant. No, in this case, Lordship, appellants only, Lordship.
against the appellants only. And there is no decree against the
Respondent number
respondent number
3.1 and 3.2.
3.1 and 3.2. And who also, who is
Against 2, yes, Lordship. Against 2 also no decree has been.
against 2, 3.1 and 3.2. Correct.
Yes, Lordship. And the respondent number, so far as 4 is concerned, she has already expired, Lordship. On last date, Lordship, I placed some document to that effect, Lord.
Okay, first of it is further submitted that insofar as respondent number 4 is concerned,
She is the mother of 3.1 and 3.2.
who is the mother of respondent number 3.1 and 3.2?
That is the legal heirs of 3.1 and 3.2 are legal heirs of
She died on?
in 2009 itself, Lordship. On last date, Lordship, I placed one copy of a IA, Lordship, interlocutory application before the court below, Lordship, filed by the plaintiff before the court below. Therein that fact has finds pension, Lordship. 2009 November, I think. Lordship, may kindly see the last order, Lordship.
Yes, but here it is written, Mr. Nayak, Learned Counsel for respondent 1 submits that the respondent numbers 3.1, 3.2 are the legal heirs of respondent number 4.
Yes, sir.
And the said fact is apparent from IS Civil 1262.
What photocopy was published, Lordship, on last week? Very good. Lordship, this is a photocopy of IA Civil number 1262 2016.
1260 is here. Therefore, we are looking at the original order.
Original order, on last date, it was on the basis of my furnishing this copy, Lordship, that was.
No, the record is here. We'll go by this.
Yeah. Lordship, in fact, records relating to RSA 256 2015 is before your Lordship. That record is there.
But in this case, there was no substitution.
My submission was substitution is not required because legal heirs are already there, 3.1 and 3.2.
Okay. It is also submitted that as per order dated 24/2026, in view of orders passed in IS Civil 1262 of 2016, no substitution petition is required to be filed in respect of deceased respondent number 4. Next, therefore, on. Not therefore, the rest of the order is there. So we are sending it to Lavazima. After their order, it will be listed before the court.
Lordship, my only prayer would be, Lordship, to give a fixed date, Lordship. Otherwise,
It will always come. Because this will go to the Lavazima, they'll pass orders after listing and then send it immediately. I don't think they will make a delay.
Lordship. Lordship, the interim pass in the IA may be continued, Lordship. Interim pass in the IA may be continued.
In which IA?
IA number 3208.
In IA 3208. Interim order passed, both sides, the petitioner and the respondent one are represented. Interim order passed earlier, stands extended to the next date of the state.
Obliged. Obliged, Lordship.
Should be no delay because we have asked the order to be placed before the AOG. Happen immediately.
Obliged. My only concern, Lordship, she is the only widow living in Gauhati, Lordship. Her siblings are already out abroad. And this matter is going on since 2008.
You make a, after a week, make a prayer for listing. That
Lord.
doesn't happen.
Obliged, Lord.
Just remind us of the today's order. Keep a order passed today ready and make a mention on after.
Obliged.
Item 21.
Lordship, we have received affidavit in reply today only. They have filed an affidavit in reply, Lordship. That
Very good in reply.
we have received today, Lordship. The matter may come up for admission, Lordship.
Who's the decree holder in you two? Who is the decree holder?
Yeah, you are the decree.
You are the decree holder. Both sides are represented. Is as to it and counsel for the respondents. Permit that he has received a copy of the affidavit in reply filed by the petitioner. They this for some time to obtain instructions. Next one. Based on 18/5/2026.
Followed interim order will be filed.
Interim order passed to be and send it to the legal.
Obliged, Lord.
Obliged, Lordship.
But Mr. Ghosh and Ms. Todi, on 18th, when we are taking up the matter, you just flag the records relevant part.
Yes.
Take it before that and flag the relevant part which you want us to refer to.
My
Records are too enormous.
I'll try to submit a written summary of.
Whether you do or not, we are not bothered.
No, my lord,
But this you'll have to flag.
yes.
Even if you give a written note without flagging this, you
Yes.
reject that written argument there and then. To make it very clear. We don't want to shift with 1,000+ papers.
Lordship.
Obliged.
No flag. Written argument is rejected outright.
So my lord, I beg pardon, Lordship, what I have to then submit, Lordship. No, no.
Like this, whether you do your written argument or not, we are not bothered.
Yes, my lord.
But this record you'll have to flag whichever you want us to see.
I see. Court record, Lordship.
Court record this.
Yes,
record.
yes, Lordship.
There's more than 1,000 pages.
Lordship.
You're not
I understand.
spending time in preparing the records.
Item 22.
Your Lordship, the leading counsel in this matter, Dr. Asim Chamua, had earlier sought permission for appearance through video conferencing today, but he is unwell since yesterday and his health is further deteriorated today. Therefore, your Lordship may kindly accommodate for today and fix a date for the same.
No, this is not his case. This is a different matter. Just tell them. Not. We thought that this is a part of that record. Okay.
22 it is.
22. Part of the month.
What's the represented?
No, interim may be extended.
What's the submitted to the council for the week is in this post. Accordingly, matters transacted on today. Interim order passed today and extended to the next date of which next for a list of when
Any date may be, your Lordship.
make it Monday.
Obliged.
18th of May.
18th.
That in the last order, in the last case, we commented about flagging of the record, which was mistakenly dealt to them. This is your record. You have to flag it next Monday. If you want us to look at any record, please flag it. I misread this to be a file of the other last case. Give us call for this case study and the other side lawyer was Mr. PJ Ghosh. Mr. PJ Ghosh and Mr. Study in the last matter. It's called for them to come back. Yes, item 23.
It's a petition, Lordship.
One four.
It's a petition, Lordship. Last petition, record of not received, Lordship. Wait.
Who's appealing for respondent two? No.
No, I am paying for as no one,
The service is not complete.
not complete.
What record is required? The service report will never come. We'll have to take first steps.
Lordship.
You have given two address in one column. One in the, you have seen what has happened. In your cost title, you have given two address.
Yes.
And in both the addresses,
Second
only
address.
one notice is sent.
Residential letter, original letter, permanent letter.
But steps, how the steps has been issued, same thing, they have copied it here. They have given both the addresses. One address is at Sri Bhumi, the other is in Aizawl. So you are still, and there is only one, what you call, in one address, two addresses are combined. So your service report will never come.
Send it to the old address, original address.
We have this, that's why we are saying, where you have sent, we don't know. But when we see the records, it's should have given two addresses. They should have taken two registered posts. For Mr. James, Next para. See that in respect of respond number two, he has two addresses. So the process was sale in one envelope for both the addresses. So therefore, there may not be any likelihood of early return of notice. The return of service report, according to the petitioner, is directed with steps within 2 days for service of notice of the respond number two, separately at both the addresses. The notice is made returnable on 17/6/2026. Next para. Order dated 25/3/2026. Allowing the learned trial court to take steps for facilitating hearing of the petitioner through video conferencing mode and extended to the next date of the hearing. List on 76. 76.
Offline.
Just we'll add one more thing. Mr. Suleiman, just add one more thing. Next, the learned counsel for the petitioner is granted liberty to collect the postal receipt number and to submit postal track report prior to the next day.
24.
May I please, your lordship? Lordship, as per the office note of 7 May, your lordship, the AD card has not returned along with the unserved notice till date. Lordship, Lordship, I have a humble prayer, your lordship. There is an interim prayer, your lordship. That is to keep events the title execution number 2 of 2021, your lordship.
You are the decree holder.
Yes, your lordship.
Your prayer was rejected.
Lordship, what happened? The title suit number 76 of 2018 was in our favor, your lordship.
Then we filed one title execution, your lordship. And in a very later stage, your lordship, the revenue authority, they found out that there is an omission, your lordship. That is,
We have
even the,
difficulty in appreciating those things. I'll tell you why.
yes, your lordship.
You have obtained the decree for this pink part.
Yes, yes, your lordship.
Then what you do is file an application before the executing court that there is an error in the description, and therefore please include this green part also. And thereby you get a decree for this land, which is not your pleaded case anywhere. In a decree under Order 7 Rule 3, what you can do is that only if there is a misdescription of the boundaries or otherwise, and if it matches with the boundaries, survey numbers, if the land can be identified by survey numbers, then the change of boundary can be permitted. But you can't take a decree for this. It may be a consent decree. You will take a decree for this and execute it here.
Lordship, the area is same.
It's not a question of area. You have a land measuring 1 katha somewhere.
Yes, Lord.
Now somebody obtains a decree for 1 katha next to you. Will you permit him to change the boundary and come to the 1 katha land of yours? You can't. If the order of the trial court is correct, you see, whatever commission you have to make it earlier. After that, you make a commission and then say that no, X is not my land, Y is my land. What is wrong with the order there? Okay, it's your execution, we extend the stay, there's no problem. See, that Miss, your name is P. Das.
P. Das.
Miss P. Das now comes for the petitioners. In view of the office note dated 7/5/2026, let the matter be listed before the Laosima court for passing appropriate orders as regards service of notice on the respondent. Yes, same thing here also. Look at your page 9. Compare it with page 7. Same thing has happened, which I've given you the example. Schedule A. Schedule A is not Moqsed Ali. South is Noor Ali. East is Sakin. West is Moqsed.
Yes.
Now, in amendment of the schedule.
Yes, Your Lordship.
You see, earlier schedule A area was how much? 2 bigha 3 katta 7 lachas.
Yes, Your Lordship.
Your amendment land contains 4 bigha 3 lachas. So double the amount of land. Exactly same, which I gave you example. exactly same. And now there's a description is, north is Mokshed Ali, south is Noor, these two are matching. East is now land of Fuzzy. That means you have traveled from here to here and now this is your boundary, Fuzzy. This yellow, this orange is Fuzzy. And then west is Mokshed. Now it comes land of plaintiff, which is not even here. You're extending the land to some other place.
Lordship, Lordship, if there is some error in this, your Lordship, and then your Lordship,
Land will double after degree.
no,
I
that-
need that land. And everybody, 15 people are here. Everybody needs that land, which expands after years. You file a suit, it is 1 katha. You end the suit, it is 2 katha. You'll be glad. My court master is also filing. They are also need of that land. There's only one way that can happen. If a material right falls, then there's a depression and the land expands to this much.
Lordship,
I've got the story, the lordship will not do.
no,
They got the story.
Lordship, the title execution was in my favor, but then we went for.
Can't happen. The trial court is right. We
Yes.
can't even allow you to spend time on waiting for the response from the parents of the respondents.
Lordship,
See, that is what happens. Why they will not appear in an execution case where they have lost? They will not appear because it's not their land.
yes, yes.
So in an execution, they did not appear. Correct? They did not appear.
They didn't appear.
Correct. So that means you get a decree and then by what do you call it? It's called permissive decree. They don't appear. And then next morning you file an application, include the other land and then get it executed. You won't permit that. It can't be permitted. You can't expand the land to double from 2 kathas to 2 bighas to 4 bighas.
There is something missing here, Lordship.
We don't know.
On the
See,
next day, that,
this is your petition. I have
Yes.
just read it and random.
yes, yes, Lordship.
I just read it and random. I gave you an example without looking at the facts. I just gave you this example without knowing what is inside. And what I said has come out true. That is absolutely right. You have to dismiss your application. You have to.
Lordship, give me one more date, your Lordship. I'll work on this and bring something on the table, your
So we
Lordship.
have worked it. It will take some time to do the arithmetic. I have done it.
No, I'll take instructions from my senior, your Lordship.
It can't happen. You see, the land cannot expand to 2 because
Yes, yes, sir.
if you get that land, 15% here, we are ready. Only I will be the one person who can't take advantage of my own orders. Then I have to exclude myself. Just cannot take benefit of his own orders. So I exclude myself. Others are there.
Can I pray for one more date, your Lordship?
What is this one, so? You have the in my court. Next para. In respect of the nature of prayer made in the application for amendment of the decree, it is noticed that there are land, what do you call there are 4 plots of land described in the schedule to the plain, according to which the decree was passed. While the schedule A land originally was 2 bigha, 3 katha, 7 lecha, with different boundaries, as per the amendment sought for, the land has increased to 4 bigha, 3 lechas. And in original schedule A, the dark number was not there, and in the amended schedule, the dark number has come into place. Next para. Even there's a change in there's an addition to the pata. Where the earlier pata was KP pata number 87, the amendment is KP pata number 2 is also included. Next para. In schedule B land, the original land was 1 bigha, 1 kata, 13 half acres, 13 1 by 2, 13 half acres. Which as per the amendment has increased to 2 bigha, 1.5 acres. With an additional dark number 155 being, 155 of pata number 2 being added. In respect of original Schedule C land, the land was 1 bigha, 1 kata, 13.5 acres, which as per the amendment is 2 bighas, 1.5 acres covered by covered by additional dark number 155 of KT pata number 2. Next paragraph. As per the original Schedule D land, the land was 6 feet wide and 2.6 feet long, covered by dark number 156, which remains the same. So therefore, on the substantial land decree, there appears to be the land area is almost double, which is impossible. And therefore, the petitioner is put to notice as to why accordingly, it's more time to address the query. Next paragraph. In the meantime, the registry shall put up the matter before the Lawajima court for something appropriate orders as regards. So we go notice on respondents. Oh, sure. Just one more. Yeah, one more line. It also appears that this the full boundaries of the land is also altered substantially. The matter will be issued before the Lawajima court for purchase of the office. The order shall be brought to the magistrate AOJ, secretary section, after the orders passed in 2004. That will be listed in the court after. This item 25 and 26 will not have time to take it up.
Oh, deeply obliged.
What is this IA for? Item 25.
Yes, Lordship. Lordship, IA 114 is for the stay.
How much delay? In your application, you don't write that.
Lordship.
In your in your cost title of the application, you don't say how much delay. Application for condonation of delay in filing. How much delay you have not said?
But you have to go through the order once, Lordship, as I'm not the engaged counsel, the engaged counsel is, I'll just go through the order. Lordship, there are three IAs, Lordship. The one is for the substitution of the applicant and.
Please come one by one. We have asked the question in the first application.
Yes.
You're not the engaged counsel. Can you say that you are engaged counsel in another two IAs? No.
No, Lordship.
Second question we put in the second IA, you will again say that you are not the engaged counsel. On the ground that the engaged counsel is not relevant for the matter extension. John, today, next paragraph. We put on record that as per the office note dated 7/5/2026, no affidavit of justice service has been filed. So accordingly, the same is at the risk and cost of the petitioner. So the applicant. List after week. Item 26.
Lordship, there is the interim.
What interim when there is an IA for the recognition of delay?
There was a stay of the execution proceedings, Your Honor, on 1/1/4/2026.
In which IA?
1/1/4. Lordship.
And what is the steps you have not taken? Why you have not taken the steps?
Lordship, the
So,
justice service has been taken by one of the councils. They have communicated with the earlier council, which was in title suit 60 of 2017. The council said that they were not engaged anymore with the.
Was the order for justice service made for serving it on the council?
No, Lordship.
Then?
We tried to communicate and take the proper address of
No,
the.
you may do a communication. There is nobody stops you from doing a communication.
Yes, but we could not serve, we failed to serve the.
If you don't serve, why would you extend the stay? You are taking advantage of the court order of a stay already being granted on execution without without substitution, without continuing or delay. Please tell us one good reason for us to extend your interim order.
Lordship, chance may be given, so we can take the proper
Now,
steps.
have you produced this order before the executing court?
Yes, Lordship, I'll have to take the.
You have produced it. On service of summons is not appreciated.
Registered post has also been taken, Lordship.
Sorry. This order to take steps by registered post was passed on 24/3/2026.
Yes, Lordship.
When did you take steps?
Steps was taken after 2 days, the date of order, Lordship.
On 23/4, that is after a month, there is an office note that steps has not been taken. Your steps was received on 29/4/2026. That means you took advantage of the order of the court and you are delaying the matter.
No, Lordship.
we are not extending that stay, we are refusing it. We recall that order of stay. This is not appreciated. If you have to take steps, you take it immediately.
Yes, Lord.
If you wait for more than a month, you are disentitled to extension of stay.
Yes. But a chance may be given, we'll take the steps.
You
proper
take steps,
in-
but the interim order would be recalled. Execution would not be stayed. It has to go. We don't encourage this delay. There are Supreme Court orders which says that dispose it of in 6 months. How will you do it if you don't take steps in the High Court for more than a month? No, sorry, we are recalling that order. Your name? Your name?
G Das Lordship, on behalf of
Mr.
P
G.
Das
Das,
Lordship.
Learned Counsel, enters appearance on behalf of Mr. A. Ganguly, Learned Counsel for the applicant. He pays for some time as the Learned Counsel for the applicant on record. It's not available. Next paragraph. He is also paid for extension of the interim order past year. Next paragraph. It is it seems that by order dated 4/2/2026, while staying the operation of the executive, this court had directed notice to be served by the C, which is made returnable on 11/3/2026. On 11/3/2026, none appears for the none appeared on call for the applicants. And on 24/3/2026, submission was made that notice could not be served on Dusty, and therefore prayer was made to allow the applicants to serve notice on the respondents by Dusty, speed post. Though orders for taking steps by speed post were passed on 24/3/2026, as per office note dated 23/4/2026, which is after a month, no steps was taken. Steps was received by this registry only on 29/4/2026, and without any delay, notice was issued on 29/4/2026. How the return of the notice is awaited. Therefore, after obtaining the order of stay, the petitioner had taken more than a month to take steps for service of notice on the respondent as ordered by order dated 24/3/2026. Therefore, the court finds no reason to extend the ex parte stay when the application for condonation of delay is pending. Next paragraph. The cost title of the application. The delay that is offered is not mentioned. However, from the order dated 21/1/2026, it seems that the here for condoning of delay is for 2180 days for filing of substitution petition, and for deceased respondent number 2, the delay is 948 days. According to the interim order, the court does not leave it fit to extend the interim order. Next part, however, service of notice on the respondents, the petitioner would be the Learned Counsel for the petitioner would be permitted to press the prayer for interim relief on the next date of this thing. Next part.
Let the matter be listed before the Lava Ziva court. On. In the week commencing first 1/6/2026, by which time 1 month would have expired. 1 month of issuance of notice would have expired, and the matter be listed before the court immediately thereafter. Next, let the order be brought to the notice of the AOJ, second appeal section. Yes, 26.
Here, my lord, 98 days delay in filing this CRPIO, my lord.
98 days.
98 days, my lord. Initially, we have filed as a civil division petition, my lord, then we withdraw the case and again filed as a civil division IO, my lord.
Okay. But this we can then CGC for the applicants. First of all, this interlocutory application. Really, following the delay of 98 days beyond the period of limitation in filing the connected civil division petition. So, CRPIO. Okay. Next, issue notice returnable on the date after 1 launch principle. The applicants shall take steps for service of notice on the correspondent by speed post with in addition, court permits the applicants to serve notice on the respondent by rusty mode by routing the process to the registry of the court, and upon service and agreement of service shall be filed prior to the state of the state. Next, step to the today. It takes steps within 2 days. Then list on 17th of June.
Master blessing.
Yes, Mr. Day, you are waiting for a long time.
Item number 29, my lord, supplementary.
29.
29.
Do not have time.
29, my lord. My lord, service report, I have taken steps, but service report by speed post, it is returned insufficient
We'll list it day after
address.
tomorrow. We're listing it day after tomorrow. All these leftover cases. Leftover cases. List. Not be taken up due to positive time. List on 20. Oh, sorry, it will be.
My lord, may it be Friday, my lord.
Friday, okay.
Friday.
Friday. Problem.
Thursday,
Yeah.
Thursday.
Okay, Friday, no. That's Friday. 15 more, 13 more.
Okay. All these leftover matters will be resolved.
Yes.
13 more. That's fine.